Namaskar and a warm welcome to our participants and speaker for the day, Shri Kapil Goel ji.
Thank you, sir.
We are extremely fortunate and privileged to have Kapil sir with us, who in his extremely busy schedule has consented for our program. When the program was still being structured, Kapil sir was the first speaker to have crossed our mind, and when we approached sir, he gave his consent instantaneously. Once again, thank you very much, sir. Not
My pleasure,
standing
sir.
between, not standing for too long between you and the participants. I request CA Nikhilesh to quickly introduce our speaker to the participants and get the program rolling.
Thank you, Deepak sir. And just to follow Deepak sir's suit, Namaskar, Kapil sir. Again, an absolute
Namaskar,
privilege to have you with us.
Namaskar, sir. Namaskar, sir.
Thank you. As a quick introduction, of participants who would have joined a little early would have also already witnessed that it's going to be an absolutely cracker of a session. I was also a participant of Kapil sir in two previous Kapil sir sessions in two previous occasions, and it's going to be an absolute great session for all of us. Firstly, good evening and welcome to all the participants. I would welcome you to the third session of the ongoing intensive ITAT appeal program of KSCAA. My name is Nikhilesh and I'm a part of the Direct Tax Committee, and it is my privilege to welcome and have you all join today's session. Today's session is going to be on representation skills in ITAT appeals and headed by our very own Kapil Goel sir. With sir's permission and Deepak sir's permission, I would just like to have a few minutes of your time to introduce.
Yes, sir. Sure, Nikhil bhai. मैं भी दो तीन चीजें बड़ी important निकाल रहा हूँ अलग से मेरे को मिल जाएंगे. I want to steal that 2-3 moments.
Absolutely, sir. Thank you. Before that, I would just like to take all the participants through Kapil sir's momentous professional journey. Sir is a bachelor in commerce from the Delhi University and a fellow member of ICAI and also a law graduate from the Meerut University. At present, is a practicing advocate before the Delhi High Court. Prior to entering practice, Kapil sir was also a part of various professional firms, including a couple of big four firms, and served as part of the direct tax, especially in the litigation teams. In one of the tenure in the big four firms, he was actively involved in giving technical inputs on various litigative issues to teams working in different industries, corporate teams working in different industries. Apart from this, sir is a frequent and an absolute blast of a contributor when it comes to legal articles on various fronts before various mediums. It could be newspapers, it could be online forums, etc. Taxman, NIRC, ITAT, Mumbai ITAT bar website, Indian Express, to name a few. Along with that, he's also a member of the Direct Tax Representation Committee in the All India Federation of Direct Tax Practitioners and has frequent interaction with the CBDT and Ministry of Finance. With this, once again, sir, Namaskar, warm welcome, and the stage is all yours, sir. Thank you.
Thank you, Nikhil bhai.
Thank you, sir.
Thank you, sir. See, I humbly give my regard and respects to Deepak bhai, Nikhil ji, and all of my participants who have joined me in this program. This is a good endeavor of this association. You have already invited me in this, I believe, in this calendar year itself, on the topic of Section 148, etc., Karnataka CA Association. And the point which Deepak bhai has made it out that he has kept, I believe it's a type of a course. Jahan par you have made it a point that you will impart some kind of important practical knowledge to your participants on how to make better and forced representation in the courtrooms. So, Deepak ji, it is like this, that the book which I was carrying in my hand, I would like to show it to my participants because I believe it is a Gita Bible for many of us. And it is still, I see the book is this Before the Memory Fades by Faceless. There is a chapter in this book which I had read at least 100 times, but I will exhort on my participants to, मैं आपको भेज दूंगा उसको scan करा कर भी. There is a chapter known as School of Hard Knocks in this book by Mr. Faceless. Faceless, we all know, he has been the legal eagle of this country. He has written this book on his autobiography type. In his book, he has a chapter in that book. In this book, he has written a chapter of School of Hard Knocks. School of Hard Knocks, you know, means bar, the lessons in the bar and the lessons for the youngsters, how to make better representation. So it is a treat to read that chapter. There are some invaluable advice which we will never find anywhere, which is contained in that chapter, School of Hard Knocks, in this book, Before the Memory Fades, by Mr. Palias Nariman. Another book I believe I should, before starting to my point, this is another book, Nani Palkiwala, Courtroom Genius, by Mr. Arvind Datta. So that is also a Bible, I believe. Anybody who want to learn more better skills on courtroom, so Courtroom Genius is one book. And you know, as an academician, it is always a matter of some kind of satisfaction कि आपको जो पता है आप दूसरे के साथ शेयर करें, अच्छा लगता है. So I had learned a lot, Deepak ji, from these two books, Courtroom Genius and this Before the Memory Fades. On my own way of presentation have become better after reading these books. And I will exemplify also in the next course of hour and 2 hours or so, which you have given me today. So the length of the program with Deepak bhai is very long, but still I will like to take you that Income Tax Act and the various laws which a chartered accountant faces. Let us take it down that how many laws which we are representing, first of all. There are various laws, I believe. Income tax law has been one traditional, orthodox, conventional practice area. But there are many other regulatory practices which we are chartered accountant is faced with. And I believe most of the members will be chartered accountants only. So the point over here is this, sir, that apart from the traditional, orthodox, conventional practice of income tax laws, income tax related laws, there are emerging areas also, you know, where chartered accountant as a, what you say, a commercial expert and a commercial consultant, as you say, is asked by taxpayer, or you say assessee or businessman, to give advice upon. That's corporate laws when we have to face NCLT and NCLAT. That's one very important area where chartered accountants have to appear. I believe in NCLT and NCLAT, chartered accountant can appear, if I'm not wrong. And apart from that, we have now this Benami laws also, where we have Benami laws and this Benami Act. The chartered accountant is supposed to be one of the authorized representatives. And apart from that, there are FEMA related laws also, where a chartered accountant is supposed to be advisor, and there are a lot of regulatory issues, or what you say, representation issues coming in those laws also. So I believe it's a very deep chain of laws where we are, as a chartered accountant, supposed to not only give consultancy but also represent before those forums. Now those forums are typically, you can say, quasi-judicial forums. You know, this is also a very important phrase. I will like to devote a good deal of time on it. That when you represent before Nikhil Bhai, before any forum, which is a quasi-judicial forum, which is not purely an administrative forum, then what are the rules of the game? How we should conduct and how authorities should respond to us and entertain our submissions is an important point. The representation before the forums, which are typically quasi-judicial. ITAT is a quasi-judicial form. GST tribunal, GST authorities are quasi-judicial. So, so all these authorities basically are quasi-judicial. There is no doubt, for the reason that they are not purely administrative. They are to act in a quasi-judicial capacity, because there is some question before them. There is some debate or contest before them, in a sense that it's not a purely litigation, civil suits are kind of a thing, but there is some issue before them which they are supposed to adjudicate in one or the other way. So that is a typical characteristic of a quasi-judicial function. So it is not typical administrative function, and those authorities who are quasi-judicial have to follow principle of natural justice, have to be fair, have to be transparent, have to follow the constitutional norms. So quasi-judicial authorities ke samne, and before we go, we have to have our what you say, arms and ammunition ready in accordance with the same. So what is happening is that when we, and this is one part, how to appear before forums which are quasi-judicial, Deepak Bhai. There can be another area that Mr. Goel, now a lot of things have become faceless also. We see where we are not supposed to go to the officer concerned physically, and we don't know also who it is. We are to communicate through virtual and video conferencings and all these electronic submissions and e-filings, all those things. So there is a portal through which we enter, through which we communicate with the authorities. So that portal is, now portal is a word which sometimes people say in a lighter sense, that portal has its own glitches and all those things. So that is another way that when it comes to representations and when you have to make representation on the portal, Deepak bhai, it is having its own challenges. So one has to have that kind of knowledge in its mind. Ki saab portal mein hum ja rahe hain, to Mr. Goel, what we should do? That is point A, quasi-judicial, B, portal. Portal is a mode of communication. Portal is not a different kind of authority as such. Portal is no authority. Portal is a medium of communication. Is a mode where, just say for example, if you send something through electronic mail, something you send through post, that is as simple as it is. So portal is not a different authority as such. Portal is not a different zone in itself. I remember on a lighter side, Deepak bhai, on the evenings, we are discussing this subject on the evening to make it lighter. What happened in a battle? I will just to make the things lighter. What happened in a court case which we were fighting in 200, 300 writ petitions were there of various taxpayers. Our officer also had 5-6 writ petitions. What was the issue in that? The issue, you will remember, my friends will remember, immediately connect. When this new law came of 148 section from 1st April 2021, 31st March was the deadline date for the new law. Now it's a different matter. They extended the time and all those things. I'm not going into the data for the moment. But 31st March 2021 was the Antim Din, Antim Tithi for whole law. So you know na Antim Tithi. Antim Tithi means the last day. So what happened? There were hundreds and thousands of notices across India, Deepak bhai, were generated. In the hush and rush, what department did कि उन्होंने बना तो दिया notice, पर उसको sign बाद में करा. आप समझते हैं ऐसा हुआ? Am I with you? You can open your mic, Deepak ji. See what happens कि आपने 31 मार्च को नोटिस बनाता है और आप उसको 10 दिन बाद डिजिटल साइन कर रहे हैं और फिर भी आप कह रहे हैं ये नोटिस 31 मार्च का है. सो वहां डिपार्टमेंट ने पोर्टल का बात कहाँ आया, मैं उसको कोरिलेट कर रहा था, बड़ा इंटरेस्टिंग. डिपार्टमेंट ने निखिल जी क्या कहा कोर्ट में, हाई कोर्ट में, दिल्ली हाई कोर्ट में, दैट यू मस्ट हैव रेड, उसमें हमारा भी लिखा हुआ है नाम, मतलब हमने भी असिस्ट किया. तो सुमनजीत कपाल का भी दिल्ली हाई कोर्ट का एक ऑर्डर आया तो उसमें मेरा भी मतलब असिस्टेंस रहा कोर्ट के सामने. तो वहाँ इशू ये आया दीपक भाई कि डिपार्टमेंट ने बहुत वेहेमेंटली रिकॉर्ड पे एक बात कही. सोचिए कितना ये कितना अदरवाइज लाइटर सेंस से बोल रहा हूँ मैं, कितना चोकुलर टाइप लगता है कि डिपार्टमेंट का ये आर्ग्यूमेंट ही कि सर हमने ये नोटिस बनाकर जब पोर्टल पे डाल दिया तो पोर्टल अपने आप में एक अलग संस्था, एक अलग ऑर्गेनाइजेशन है, जिसको चला गया तो एओ के कंट्रोल से बाहर हो गए. I repeat what Revenue said in writing the counter affidavits on the Honorable High Court in Delhi in these cases about portal working. They say that when AO issued the notice, prepared the notice and put it on the portal, AO is functus officio and it is the portal whose job is to take it to the assessee. How you sound? How this argument sounds to you? So department sometimes treat portal as an unit in itself, as an independent silo. मतलब क्या कहते हैं उसको, उसका अपना आप में entity बना दिया उन्होंने. जबकि in my humble opinion, in our understanding, that portal can never be an independent entity, sir. Can portal be an independent entity, sir?
Part of the department.
Part of the system where through which I am just as a medium of communication, sir. Nothing more, nothing less. Portal cannot be made as an entity in itself that who is given a function, who is given a functional role, some kind of it, independent functional role. So anyhow, I was taking that we are appearing before various quasi-judicial authorities. We have to appear in the faceless mode through portal. Then it comes, Deepak bhai, when we have to do a lot of drafting work also. We as a chartered accountants are engaged in preparing submissions and write-ups and synopses and what you say paper books before various authorities. So how to prepare that is a very important part of the practice representation, because practice representation and courtroom practice consists of two things. If you further make a what you say segregation of it, one is the oral representation and second is the written pleadings. Now pleadings have its own role. You know, in courtroom, when we prepare writ petitions and when we go to High Court, High Court has writ petition jurisdiction also under the Constitution of India, Article 226. And Supreme Court has SLP jurisdiction under Article 136. So Though as a chartered accountant, we can't appear in an arguing manner, but yes, we can definitely, we are somewhere indirectly engaged, Nikhil bhai, in getting them vetted, or what you say, with the counsel concerned. So that is also an area that how you prepare your pleading, how you bring out the point of issue before the court concerned in your written arguments. Everyone can have different way of presenting himself, and there can be no way, what you say, abstract way, one has to represent in this way only. So what I am outlining is, in my brief prefatory remarks, that written representation, written submissions, and written pleadings have its own very serious, significant role, drafting of them. I can say I'm still learning. I am yet to learn many things. It is a dilemma to me, irony to me, that you have invited me as a speaker to speak my point. But that's a different thing. But I can tell you with all humility and humbleness that I am to learn it. We are to learn it always. We have to always improvise it. Are you getting my point, sir? So there is always a scope for improvement, as our Supreme Court, Honorable Supreme Court judges and great jurists have said, that there is always some scope of improvement, Nikhil bhai. I can tell you my humble experience, that I have argued hundreds, thousands of cases in the tribunal and the court. But I take it as a challenge to me. Whenever new brief comes to me, I want to see that my presentation goes better, one step above in that. And I will try my best today in this session to communicate it, that how I am doing it. It is up to you. You take it worthy or not. That is up to you. Sorry, with due humbleness. It's a perspective which I will keep out. The point is this, that we have to always see, Deepak ji, that the case which comes to us, there can be a way that Mr. Goel, there is a template, we get it cut. Please don't mind. I'm not on any person, please, with all humility. The point is this, if I make a template, then I use it repeatedly, that is one type of practice. But if you have some kind of uniqueness and distinctiveness in each pleading and drafting, that's a different challenge to you, sir. Now you take it from Messi. We have seen his playing, his skills in the cricket, football. I'm not a football, but I have, what a man he is. See, we should learn from these sportsmen like Virat Kohli sahab, how they improvise in their way of playing. So in our work, we are doing legal work or regulatory work, or what you say, statutory works. This statutory pleadings, Nikhil bhai, has to have that kind of distinctiveness. We should try. We should make an effort that in each case, although you may have penny stock, 68, 148, 148A, hundreds of cases, but you should always take it as a challenge that you will not only go by template practice. My point is taken well note of by my participants. The template practice should not become a impediment, a barrier in our improvisation. I have seen in our great profession that that sometime to get the things done in an easy manner, Deepak bhai, we use templates. It has its own hazards also, or that has its own, what do you say, limitation factor. It limitizes your skills. Your drafting skills, your presentation skills can come out beautifully when you try to give every brief its own points. I hope you take it like that. Now, I was talking about, sir, if you see as a chartered accountant, I asked you, Deepak bhai, you are a very, what do you say, engrossed and a very learned chartered accountant, that how many laws you find that CA is an authorized representative?
In practice, it is more of taxes, income tax, maybe the state level laws like profession tax, GST ho gaya, wealth tax hua karta tha.
Black money, yes, black money law ho gaya. So I believe, in how many cases all of us, I'm asking a very humble question. When you do your work of pleadings and drafting and representation work, how many times you keep in your mind the Constitution of India with you? Or let me rephrase my question to my audience. Rephrase. That in how many cases, Nikhil ji, you find that as a chartered accountant, when you make a representation, Constitution of India can be of use?
Very minimum.
That's an honest answer. You said very minimum, if I heard it correctly.
Yes.
But I am telling you, Nikhil bhai, it ought not be like that. Sorry. I can tell you with all humility and with all humbleness that it is like this, sir, that Constitution of India should be at the forefront when we make our pleadings. And I will try to devote 15 minutes, 20 minutes in the initial inception on this point itself. Is that how we can coalesce Constitution of India with our day-to-day pleadings and make them more stronger and forceful? Deepak bhai, what is the relevance of Constitution of India in the pleadings by chartered accountant, and how it can improvise and take it level up? That is the point I'm taking up. I hope my point is taken note of, sir. So you
Yes,
all
sir.
know, you be attentive with me now, that Constitution of India is that holy document which our constitution makers and our great people who have fought independence has given us, and we got this constitution which is the connecting factor for the entire country, and it has some of those very important what you say, sir, ingredients or things in it which can always give a push to your pleadings. For example, let me illustrate it. For example, you are making a written submission, let us say to the assessing officer in the income tax law, in the faceless assessment, where you are given a show cause, Deepak bhai, that why not this addition should be made in this particular assessment to the written income. That's a raw question. So point is this, if you are having any show cause notice issued to you by the faceless assessing officer, FAO, FAO, you know FAO na? There is a JAO, there is a FAO. This is FAO. So you have to make the submission in the reply to show cause notice. That kind of show cause notice can come in various laws. Show cause is a typical document which department generates in Customs Act, GST laws, and various laws. Now you have to make a pleading in the show cause notice. Now show cause notice ka reply banate waqt, what points you can get from Constitution of India is my point. And that will travel to appeal also. When it comes to first appeal, when it comes to a representation before tribunal, sir. Now, first thing is this, that we are using it as a supporting thing. Definitely, you will have to have, nobody can say, Mr. Goel, if you are using Constitution of India to push up your pleadings, that does not mean that basic provision of that particular law will have to be given a go by. I hope I'm clear.
Yes, sir. Income
Tax Act has definitely to be kept with your chest at that time. There is no gainsaying. But at the same time, I'm just supplementing that you have to keep Constitution of India also. And how can you do it? First thing, you have to note what are the relevant provisions of Constitution of India, sir, which can keep us helpful in our day-to-day practice and in our oral representation, in our note it down. You can note and written represent. There are 5, 6, or rather 8, 9 provisions of Constitution of India. Although entire Constitution is very important, Deepak bhai. Go to any authority. I would implore on all of you, with due respect, and I have said in various seminars, I am saying this also, Nikhil bhai, I have said in my various seminars, many people might be seeing that I am repeating it for a point, but I want to make it very, very clear that Constitution of India is something which nowadays the kind of attitude, with due respect to various regulatory authorities, we must always have. If you want to protect the rights of your client, you have to have your mind Constitution of India. I'm telling you. Let you take it like this. Minus Constitution, if you do something, sir, the level will come very down. Plus Constitution, you will take it, the level will be very high, and you will realize it. And I will ask you, Nikhilji, and you, Deepakji, that how you feel it after 5-10 minutes when I go through this, my entire things of Constitution of India. First point is, sir, our part 3 of Constitution of India, where our fundamental rights are written. There is an Article 14. Now, what is Article 14, Deepak bhai? It says that all the countrymen, all people, as far as all countrymen are concerned, state shall give them right to equality. All will be treated with equality. That is known as Equality Protection Clause. That is right to equality under Article 14. Now, it looks very or to some person is that what Article 14 Mr. Goel will give us in tax practice or the day-to-day practice. But may I tell you, Nikhil bhai, I'm telling you, this is in itself that kind of provision. If we understand it properly, मैं नहीं समझ पाया उसका 1% भी. I'm telling you, जिसने इसको वन जैसे कहते हैं ना, some people have said कि हमारा ब्रेन में अभी किसी ने सबसे ज्यादा ब्रेन किसका यूज हुआ है परसेंटेज में, ऐसे ही आर्टिकल 14 का पोटेंशियल अभी यूज ही नहीं हुआ टैक्स लॉज में सर. और आप देखिए क्या पोटेंशियल, यू सी इट. Article 14 is a provision in the Constitution of India which says that right to equality will be granted by the state to all the countrymen. Now, looking at plainly, it means कि right to equality means all will be treated with equal sense. मतलब equals will not be treated as unequals and unequals will not be treated as equals. That is the point. But our Supreme Court of India, our Honorable Supreme Court of India, see, when you read Constitution of India, some people say कि Constitution can be read like a statute. No. Constitution will have to be always reading with a liberal sense and with a broader sense. It can never be read in a strict manner or restricted manner. So Supreme Court in 5 decisions I can make you note down. You can note down quickly. There are 4-5 decisions in Article 14, Deepak Bhai, where this Article 14 has been given absolutely different dimension now. Now let us start with Shaira Banu's case of Supreme Court of India 5-judge bench. Famous case of triple talaq. Shaira Banu's case. Shaira Banu. SHAYIR Shaira Banu. It is applied by Justice Nariman. You know Pepsi Food का जो केस आया था ITT का स्टे वाला सेक्शन पे. Pepsi Foods Limited, Supreme Court has applied Shaira Banu in income tax matter also. Now what Shaira Banu said in triple talaq is known as famously triple talaq case. Shaira Banu is one of the landmark case, epochal case, where our 5-judge constitution bench Deepak Bhai said that any law which will be manifestly arbitrary will be struck down. The test of manifest arbitrariness was read into Article 14 by Supreme Court. That it is also a ground to test the validity under Article 14 itself. Because why Supreme Court said it? That something, right to equality is one part, equality का opposite क्या है? What is opposite to equality? I ask you, Deepak ji. Equality का opposite है arbitrariness. So Supreme Court has interpreted Article 14 in a very, very different manner, in a positivist manner. What they Nikhil ji say कि any action by any authority, you note it down what I'm saying. Every word will have its meaning. I'm telling you, any authority under any law doing any act which is arbitrary, note the word arbitrary, is violative of Article 14 of Constitution of India. So you will ask Mr. Goel, is this law settled now that Article 14 grants every person a right that any state authority will not be arbitrary in its approach? Answer is emphatic yes. Shaira Banu is one ruling I told you. You can note 3 more rulings here. Ajay Hasia. I am giving a layman से, मतलब आपको मैं ज्यादा बोर करने के सेंस से नहीं, जिससे आपको दिलचस्प भी लगे. अजय हासिया का एक रूलिंग है सुप्रीम कोर्ट का, सर आप नोट कर सकते हैं. इट्स फेमस अजय हासिया.
Yes, sir.
And third one is EP Royappa. EP Royappa. अजय हासिया, EP Royappa, and एक है इंटरनेशनल एयरपोर्ट अथॉरिटी का केस. ये सब आप गूगल पे करेंगे आर्टिकल 14 डाल के, तो गूगल साहब आपको, गूगल जो उनको बोलते हैं गूगल अंकल, he will help you out. So without boring you with these citations, but I'm giving you Ajay Hasia का केस हो गया सर. I'll memorize it like this. EP Royappa, International Airport Authorities case, and this Shaira Banu's case. All these things combined together, Deepak Bhai, it clearly says any action of any state authority, any authority under any law, if arbitrary, is violative of Article 14 and has to be struck down. Now, this protection is given to us by Article 14. It is inviolable protection. Now, it is that article, sir, Nikhil ji, which gives us, एक तो arbitrariness का आपको protection दे दिया कि arbitrary action किसी भी authority का अगर होगा तो Article 14 उसको clip कर देगा. जैसे एक snake, मतलब ये सॉरी सर, जैसे एक हमारा क्या बोलेंगे, कैसे एग्जांपल दें आपको, कि जैसे कोई भी आदमी अगर आर्टिकल 14 का वायलेशन में आर्बिट्ररी एक्ट करता है तो आर्टिकल 14 का टीच में आ जाएगा. वो आर्टिकल 14 उसको क्या करेगा, आर्टिकल 14 कहेगा कि सब इस एक्ट को नलिफाई किया जाए. और बहुत सारा आर्बिट्ररी एक्ट, दीपक भाई, हम तो ये कहने का जरूरत नहीं है कि मिस्टर गोयल व्हाट इज आर्बिट्ररी. नेक्स्ट क्वेश्चन कैन कम टू योर माइंड. आर्बिट्ररी वर्ड आर्टिकल 14 में नहीं लिखा है. कोर्ट्स हैव रेड आर्टिकल 14 लाइक दैट, सुप्रीम कोर्ट. नाउ क्वेश्चन विल कम मिस्टर गोयल, इस आर्टिकल 14 के आर्बिट्रेरी वाली चीज को हम प्रैक्टिकली कैसे कर सकते हैं? जैसे उन्होंने मुझे बार बार बोला दीपक जी ने कि मेक इट प्रैक्टिकल। कैसे करेंगे दीपक भाई? उसको ऐसा करेंगे कि साहब आर्बिट्रेरी का मतलब है, एंड अब नोट कर लीजिए, आर्बिट्रेरी इज डिफाइंड बाय सुप्रीम कोर्ट। आर्बिट्रेरी इज नो, यू कैन नोट डाउन, आर्बिट्रेरी इज समथिंग व्हिच इज इरैशनल, व्हिच इज कैप्रिशियस, व्हिच इज विदाउट प्रिंसिपल। I should repeat, arbitrary is something which is irrational, which is capricious, and which is without principle. So you will find hundreds, various actions of our, with due respect to revenue authorities before whom we daily appear, are coming within this area of arbitrariness, irrationality, capriciousness, without principle. So Article 14 can be one of your ground to attack it. Article 14 can be based to say that this action of this authority is illegal, unlawful, without, and it is even constitutionally vulnerable. See, I say it like this, Deepak ji, that when we say, somebody can always say, just we are talking about show cause notice issued by income tax authorities, 148A orders passed by income tax authorities. You can apply this test of Article 14 in all those cases. Somebody who says that, Mr. Goel, whether there is any such thing that tax assessments and tax adjudications or this adjudications by these authorities are quasi-judicial authorities are out of Article 14. I am telling you, sir, nobody can dare to say, Deepak bhai, I am saying like this, nobody can dare to say that anybody is out of purview of Article 14. See, it is like this. On lighter side, let me make it more lighter. कि अभी क्या हुआ निखिल भाई कि आई वाज प्रिपेयरिंग फॉर सम रिट इन एन हाई कोर्ट इन 148 एडी का, जो भी आजकल 148 का हम लोगों के पास काम चल रहा है, बहुत सारा सब लोगों के पास, हमारे जैसा वकीलों के पास. So what I was thinking in my back of my mind, sir, कि मैं इसमें आर्टिकल 14 में अगर जज साहब को बोलना है मुझे कोर्ट में, हाई कोर्ट में, तो मैं आर्टिकल 14 के अंदर कैसे इसको यूज कर सकता हूँ. So I found one judgment which I want definitely to all of you to note down, and this is after a great research I found this judgment here. Now in this judgment, what Supreme Court said, sir, is a 5-judge bench order. Now this is the case of Supreme Court in one of the matters where Supreme Court says that Article 14, see, whenever it comes to the review of any action of any authority, they say even if an act is an administrative act, then Article 14 can be applied to see whether it is arbitrary or not. See, arbitrariness test does not apply only to quasi-judicial action and judicial action. See, Article 14 test of arbitrariness, you note it wherever you are writing, that it applies to all types of acts, whether they are administrative, whether they are quasi-judicial, or whether they are judicial, Deepak bhai, and whether they are legislative. See, I said 4 types of acts. Aap kehenge, Mr. Goel, what are these 4 types of acts? Let me repeat. Deepak bhai, it's very interesting discussion. Legislative act, you know, is a legislative function which our parliament and legislature do, कि जहां कानून बनाता है. आप नोट कर रहे हैं legislative function. एक हो गया legislative function, एक हो गया judicial function. जैसे कोर्ट में आप हैं, जज साहब के पास, ITT के पास, या कोई कोर्ट में है आप, जहां judicial function हो रहा है, pure judicial function. एक हो गया क्वासी जुडिशियल फंक्शन, जहां असेसिंग ऑफिसर के पास है आप, ITT के पास है, CITP के पास है. एक हो गया एडमिनिस्ट्रेटिव फंक्शन, कि जो एक पॉलिसी के तहत हो रहा है. CBDT ने कहा, आप यू आर नोटिंग माय पॉइंट सर. सो इन ऑल दीज आर्टिकल 14 हैज टू बी, इनकी आर्टिकल 14 का टेस्ट तो पूरा लगेगा इन सब पे. जैसे लेजिस्लेटिव एक्शन को टेस्ट करना है, तो वहां कौन सा टेस्ट सुप्रीम कोर्ट ने बोला, वहां मैनिफेस्ट आर्बिट्रेरीनेस का बोला. आर्बिट्रेरीनेस के आगे एक वर्ड लग गया मैनिफेस्ट. आप बोलेंगे मिस्टर गोयल, व्हाट इज द डिफरेंस बिटवीन आर्बिट्रेरीनेस एंड मैनिफेस्ट आर्बिट्रेरीनेस? आई आस्क यू दीपक भाई, व्हाट इज द डिफरेंस? It's a very interesting difference. The manifest arbitrariness test is a higher level of test. When you test legislative function, मतलब कोई लॉ बनाया उसको आर्टिकल 14 में आप अटैक कर रहे हैं, तो वहां मैनिफेस्ट आर्बिट्रेरीनेस लगता है, सिर्फ आर्बिट्रेरीनेस नहीं लगेगा. But when you are testing any state, any executive function, let us say कोई असेसमेंट ऑर्डर है, कोई शो कॉज है, कोई भी है ऑर्डर है, 148D का ऑर्डर है, 179 का शो कॉज है, आप मेरे पास समझ रहे दीपक भाई, वेरी, तो उन सब में आर्बिट्रेरीनेस का लगेगा. इट्स मैनिफेस्ट आर्बिट्रेरी इज अ हायर लेवल टेस्ट, आर्बिट्रेरीनेस इज अ लोअर लेवल टेस्ट. नाउ आर्बिट्रेरीनेस टेस्ट मींस कि दैट एनी अथॉरिटी हु इज डूइंग, अब आर्बिट्रेरीनेस को और एक्सपाउंड करते हैं थोड़ा. Arbitrariness means it should not be irrational, it should not be capricious, it should not be without principle. Let us further elaborate. Arbitrariness means it should be fair. It should be with principle of natural justice. You noted Article 14 is the, I'm telling you with all conviction. We don't realize many times that where principle of natural justice has come from Constitution of India. It is Article 14 which has given us guarantee of principle of natural justice. That every authority, wherever it is, will follow principle of natural justice is the command of Article 14. Because it is subset, see, how you say every a state authority action or a government action or government body action is with the equality. When it is fair, when it is without arbitrariness, when it is with principle of natural justice, when it is with rule of law. So all these things are in what you say are part of Article 14 protection. So somebody can say very clearly that if some action is taken without in violation of principle of natural justice, which we now see replete, our 90% of income tax cases are replete of violation of natural justice. You are in Karnataka, you will. I read Mr. Justice Krishna Kumar. One Justice Krishna Kumar is there, Ashar Krishna Kumar in tax bench in the single judge, and there is Justice P.S. Dinesh Kumar in division bench. So I was reading their orders, Deepak Bhai. You will find Mr. Krishna Kumar's order, Justice Krishna Kumar's order. 90% of the cases of faceless assessment he has set aside on violation of principle of natural justice. Many people have their own thinking about natural justice, but I'm telling about my humble point of view. That principle of natural justice is so deeply ingrained into our jurisprudence because of Article 14. And you can note down that this ground of violation of natural justice is connected to Article 14. And when you make your pleading, you can accordingly highlight it. If you find in your case there are a violation of natural justice, you can correlate it with the principle of Article 14. Sometimes people ask me, Mr. Goel, department does not understand Income Tax Act properly. What is the fun of telling them Constitution of India? See, point is not this is fun or not fun. Point is this, that it's a very serious point that department has to be made aware about their duties as per constitutional duties first. Act is not giving, Income Tax Act has not given birth to our Constitution. Constitution has given birth to Income Tax Act. Somebody should make it more clear to them that anything which is violative of Constitution of India cannot pass the muster of the law, cannot pass the testimony of the law, cannot pass the what do you say it is okay. What do we write in WhatsApp? Okay, nowadays. So that okay can come only when it is constitutionally okay. And constitutionally okay mein sabse pehla point hai Article 14. And I was telling you this decision, sorry, I forgot. This decision, Deepak Bhai, is worth reading. It's a Constitution bench order, sir. And in this order, the Supreme Court 5-judge bench has gone far beyond. When I was just saying that I was preparing for one writ petition in the High Court. I was myself just for the sake of more better, sir. Then I find this case, which I found to be of immense use across board. This is the name of the case is, sir, Shri Sitaram Sugar Company Limited. Shri Sitaram. See, the name of the case is, I always say good cases have good names, Deepak Bhai, as your smile is good. Shri Sitaram Sugar Company Limited versus Union of India. It's 1990. The citation of it is 1990 SCC 223. 1990 the calendar year, 3 SCC Supreme Court cases, 223 is the page number, 3 SCC 223. It's a 5-judge bench order, Constitution bench order. And I am telling the particular paragraph which I want to highlight is where Article 14 sense is given. See, where I was saying I was just saying, Nikhil Bhai, that Article 14 applies to all type of acts, whether it is administrative, quasi-judicial or judicial. This is one of those Constitution bench decisions. It's not even 2-judge bench, 3-judge bench. It's a 5-judge bench order by Supreme Court of India. So I don't know. Maybe Deepak Bhai, I don't know. Somebody in the income tax department when they apply these, when they do these function ना कि जब वो उसमें काम करते हैं कोई भी regulatory authority या enforcement agency, उनको शायद ऐसा लगता है कि हम पे संविधान लागू नहीं होता है. Maybe I'm sorry, this is a myth. But I'm telling you, this is a myth. Because see, para 46, I just read. Can I read, Deepak bhai?
Please, please, sir.
See, when we are in the courtroom, we have to ask my lords, my lord, can we do this act? Then only you can go ahead. Or otherwise, it can be called as contemptuous act. So I just wanted to behave in that manner. So what it says, para 46, any arbitrary action, whether in the nature of legislative, administrative, quasi-judicial exercise of power or quasi-judicial, is liable to attract the prohibition of Article 14 of Constitution. As stated in E.P. Royappa, जो मैंने आपको बताया था, versus State of Tamil Nadu, equality and arbitrariness are sworn enemies. Equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while the other to whim and caprice of an absolute monarch. Unguided and unrestricted power is affected by the vice of discrimination. Menka Gandhi versus Union of India. This is the second decision which they rely. The Supreme Court rely. The principle of equality enshrined in Article 14 must guide every state action. Now, what are the state actions covered in the Article 14? Number 1, legislative, executive or quasi-judicial. वो इंटरनेशनल एयरपोर्ट अथॉरिटी वाला ऑर्डर अजय हासिया सब इसमें इसी पैराग्राफ में मेंशन है, पैरा 46. So what I mean to say, Deepak bhai, this kind of, you can ask always, Mr. Goel, can we give these rulings to courts or income tax courts or income tax authorities? Why not, sir? Nobody can say. I'm telling you, rather it should be received happily. It is another matter that our good friends in the revenue side, many times they do not receive it happily. They have their own, what you say, problems of mindset, with due respect to them. I say on record, that they don't want to be guided about these things, guided about these things, which are cherished norms. Are we saying that these judgments of Supreme Court of India, 5-judge bench, are of waste papers?
Definitely.
I don't know. Who will see? I ask it like this: how many 148D orders? Let us take a raw question, Deepak bhai. I ask you and Nikhil ji. How many 148D orders which were passed in this season are fulfilling this test of Article 14, which we have just discussed?
I would say none, sir.
Huh?
I would say 0.
100% you are right. Because in all of them there is some sort of arbitrariness present.
Definitely.
For example, I was preparing a writ last night, Deepak bhai. I just take a point to just practically correlate it. You say na, practically make it relevant. Supposingly, in a given case, assessing officer in the assessment, in the reasons to believe which they recorded in 148, the unamended law, उसमें reason recorded था अभी information suggesting a statement of intent. Now they record some note, satisfaction note, in which they say this fact that I have not filed a return, or in which they ignore that I have filed a return, and in assuming it to be a case of non-filer, then they make the reason. Can it be called to be fulfilling Article 14? That is non-arbitrary. It is okay. The answer is clear. As you are noting, no, how can it be? I have filed a return, it is a fact. They have not seen the return, it is a fact. They have said that income has escaped assessment without looking to my return, this is a fact. Admitted fact, undisputed fact rather. I should say it is an admitted fact. We have very serious relevance of admitted facts and undisputed facts. Nowadays, Deepak bhai, I have learned very serious thing. Whenever I make any pleadings, I make a serious analysis, and I implore all of you, please note, I will forget. Before I forget, that you have to make a proper segregation of in your case, what are disputed facts and what are undisputed facts. And we should try to fight our case as far as possible on basis of admitted and undisputed. It will give you a very different result. You will see it. When you make out a case on the basis of admitted and undisputed facts, then you have a different wavelength and frequency to communicate to the court and judge concerned. And when you argue something on the disputed fact, then but it requires again marshalling of facts, very serious command on the facts of the case. That's a different type of a thing which we should expertise, or by the practice it comes, that how can we, Mr. Goel, go into those segregation of this area which you are telling you, disputed facts and non-disputed facts. This is a very important area, Deepak bhai. Anyhow, what I was saying, Article 14 has a very serious role in 148 cases. See, in various high courts in the country, my lords in the high court, we have so many high courts in the countries and so many my lords in the high courts. All judges have different approaches, with due respect. Now, what happened, Deepak Bhai? I have seen very few judges, though there are very important. That is what I wanted to underline. In South, I have seen South High Court that various judges are using Article 14 in various tax matters also. Because of this point, that this is a broader sense, this is a more rational sense, that Article 14 is not pegged to any particular class of action. This is omnibus provision. So I was advocating or humbly imploring on all my audience today, ki saab, whenever you try to make any submission or prepare your case, try to keep Article 14 with you, arbitrariness test with you. How can we use it in a case? Are you getting my point, sir? Can I proceed further now?
Yes, sir.
So that is Constitution 1 article. And if somebody gives me someday, I so much love these articles and Constitution of India. More I read it, more I discuss it, more I love it. So I tell you my sense of saying about it, Deepak bhai, that अगर आप मुझे एक दिन पूरा बोलने के लिए दे तो मुझे अच्छा लगेगा आर्टिकल 14 पे. I so much love it. Anyhow, that is not the point today. Article 14 हुआ. Next article is Article 19. Article 19 is an article which gives us concept of reasonableness. See, we all know, we have, as an Indian citizen, that we have right to freedom of speech, expression, and all those things. Hijab controversy, we all know Supreme Court gave a dissenting ruling, 2 judges dissenting. Just to connect it, I said it. So, Article 19 is again one of the most important, one of the very important article where right to carry on this freedom of business, etc. is given. Nikhil bhai. But everything, this rights in Article 19 comes with reasonable restriction, that state can and government can impose reasonable restriction. The word used is reasonable. Now let us connect it with Section 273 capital B, that penalty cannot be levied in the Income Tax Act if there is a reasonable cause. Am I there?
Yes, sir.
In Income Tax Act, this word reasonable came quite later. I am telling you the test of reasonableness when it comes to right to carry on business, right to carry on, free speech, expression, all these things, and there can be reasonable restriction. The word reasonable is a center focus point in Article 19. Any restriction imposed by any government agency has to be reasonable. It cannot be like this. For example, let us take the case of 115 BBE. Supposingly, and I'm taking a practical case, Deepak bhai, your assessee is there who is given a show cause notice in the income tax law faceless assessment that some GST department has sent some inputs regarding fake invoice. I'm connecting to the point, fake invoice. GST department sending inputs to income tax department. Income tax department issuing straight show cause notice on that. Now, what income tax department wants to do in the show cause, income tax department want to apply 69C to my recorded purchases and 115 BBE. They accept that sale has been done. They accept everything is right. Now see the section. See 115 BBE says if anywhere 68 to 69D is applied, 115 BBE will automatically apply. Somebody someday, I have filed in my office a file. I'm happy to share. We filed one constitutional validity petition before Punjab and High Court challenging 115 BBE validity recent month, and it has been admitted also by Punjab and High Court. So what I wanted to say in that, and I'm telling my viewers to take it note, to take attentively noted, 115 BBE, how I say it is violative of my right to carry on business, Nikhilji. Let us say you are that case which we were discussing, 100 rupees purchase I have done, which department say it is under suspect, and from that 100 rupees purchase I have made a sale of 110. 10 rupees is my profit. Now what department wants to do? By applying 115 BBE, department wants to tax this 100 rupees purchase, which is debited in my P&L account, as unrecorded expenditure, unexplained expenditure under 69C, which to my understanding is totally wrong. It is egregious. 69C can never apply to recorded purchases. Now, having said that, let us say for the moment Mr. Goel 69C can apply to the recorded purchases also, though it can never. But they applied it. Now what result it is giving us? It is giving us a result where Deepak ji, firstly, that is never my profit. I am into business. I am earning a very low margin of profit. Due to this thing, it is giving that kind of high-pitched astronomical assessment. Not only high-pitched,
I don't know. It should not be called as high pitch. It is not high pitch. It is something else. So what it is done now, what it is being done is that this amount of tax liability which 115BB is giving is far more than the purchases amount which you are adding now. 100 rupees is the addition. Tax liability coming out of 115BB is exceeding the addition made. Am I right, sir? Now, can you see this 115BB is passing the test of Article 19 of Constitution of India? It is a reasonable restriction on my business. Are you asking businessmen to pay something which is reasonable? Or is it not an attack on the right to carry on business? Will not I be supposed to close down my business if I have to pay this kind of liabilities? I ask it like this, and that is my question in the petition which I have filed in High Court, on the Punjab and High Court. So Nikhil bhai, we need to develop this thing with due respect to government. See, some people can say, Mr. Goel, why you are advocating that one should go on to challenge these provisions like that. Sorry, it should not be the way of looking at it. It says, sorry, Deepak bhai, our constitutional forefathers have told us, unless we question, our Chandrachud Sahab has said, Justice Chandrachud, the Chief Justice of this country, we as a citizen are supposed to question. Then only, and constitution is not something attack on somebody. Sorry, Nikhil bhai, if I am not wrong, that unless we question how the law will evolve, how it will be evolved, it is constitutionally right or wrong. So, I don't know. My Deepakji sense says me, I have said in various seminars, you have today invited me, and it's my duty to all my learned friends to say and implore on you. Try to question and try to check whether, don't go that if a law is made, Finance Ministry makes a law on the budget day, it is a gospel truth, it can never be probed. Now, Shaira Banu and the way Supreme Court has given judgments in Article 14 and 19, we all countrymen have right to question. Supposingly, if you have to challenge explanation 1 management strategy wala point. I am telling you, it is vulnerable provisions. I am still of the humble point that New Income Tax Act Section 148 explanation 1, this risk management strategy wala point is a vulnerable area. Constitutionally vulnerable area. If you ask me that deemed escapade of case under search and seizure and survey cases is also a vulnerable area. This all needs to be constitutionally challenged and questioned. Like this is a very serious vulnerable area. Deepak bhai, I am asking you a question. I have said in some seminars in last days in Guwahati and Pune, whether this test, whether this restriction or what you say requirement on the borrower of a money to give the source of lender under 68 proviso added by Finance Act 2022. Do you feel it is okay? Is it not interfering in unreasonable restriction in my right to carry on my business? See, I am no authority. I am nobody. I am a very small man. But it is our humble sense which says us that if I am a Kapil Goel, I am carrying on business, I take a loan from somebody in the course of a business, then you say that if I am not able to explain the source of the lender, then it will become deemed income my hands and 115BBE will follow it like shadow. And tax liability will exceed the amount of the loan in the hand of the borrower. And lender remains sitting on the fence. Department will not go to the lender. Everything will be done in the hand of the borrower. Is it okay as per Article 19? Is it a reasonable restriction on right to carry on business? Is it not is it question mark? All these are question marks. Is it not an irreasonable restriction? So you have to see it like this. Supposingly sometime department makes a search, Deepakji. Nowadays department after search and seizure and various laws, department now uses provisional attachment provision like anything here. You know provisional attachment, na? GST laws also have, Income Tax Act also have. This provisional attachment can also become vitiative of Article 19. I am telling you, it can be serious interference in my right to carry on business. If they provisionally attach my something stock in trade, my regular bank account, all those things. I hope you note the importance of Article 19. Reasonable what is means? Reasonableness means something which is reasonable according to a reasonable man. Which a reasonable man sitting in the same circumstances will feel it reasonable. It is called as Wednesbury reasonableness. What is reasonableness test? Reasonableness test is the test which means that what is reasonable according to reasonable man's sense. I hope you get my point of view, sir.
Yes, sir.
So Nikhil bhai, Article 14 has to be kept in mind. Article 19 has to be kept in mind, drafting the cases and pleading. And Article 21, third is very important. Article 21 is that article, sir, which says that right to carry on, or so what do you say? Sorry, right to life and liberty. Every countryman will have right to life and right to liberty. You know, right to life and liberty means supposingly some GST authority come and arrest somebody, some tax authority, without any due process of law. That is Article 21 is violated then. We all are granted right to life, and definitely you can definitely arrest an invader provided the due protection of the law, relevant conditions of the law properly, scrupulously satisfied. So liberty cannot be interfered just on the alter ego of executive. Deepak bhai, Article 21 has a very serious role. We have seen when Supreme Court 9-judge bench Justice Chandrachud gave this order of right to privacy is part of right to life. Right to privacy is part of right to life, and it's a practical provision. See how I say it's a practical provision, right to life. In various income tax cases, search and seizure, and various search and seizure which tax authorities are doing, with all respect, Deepak bhai, we have seen Article 21 somewhere is kept at bay. So these are the provisions which you can also develop. Oh, sorry, these are the articles where you can keep your point of view in the submissions and the courtroom and the practically the authorities. Sir, you please see that Article 14, 19 and 21, they are trinity of provisions. Article 14, 19 and 21 are trinity. So one can definitely keep in mind. So now after Article 14, 19, 21, it comes is the Article 136. Is the special leave petition. Power to approach the Supreme Court under Article 136 is the special leave petition. You can file against any order. You can approach Supreme Court in special leave petition, which is a discretionary provision power of the Supreme Court, where it can admit your SLP if Supreme Court otherwise fails it. Generally, what happens is Supreme Court says come through High Court and come through lower court. So Article 136 is a special leave petition. You should be familiar with it. All the cases in which Nikhil bhai, all these cases which reaches to the income tax cases, maybe जो हमारा tax appeals के खिलाफ हाई कोर्ट के ऑर्डर के खिलाफ या रिट ऑर्डर के खिलाफ फाइल होता है, वो SLP ही होता है. और इसलिए आप लोगों को SLP का पता होना हमारे को जरूरी है. SLP is a Article 136 is a provision which is a discretionary provision. इस पे 5 judge bench के income tax law का order आपको लिखा देता हूँ. You want to note it down. That's a very famous order. Deepak bhai, you must have read it. Dhakeshwari Cotton Mills. What is the scope of what do you say? What is the scope of Article 136 has been adumbrated by the Honorable 5-judge Constitution Bench of India in this locus classicus of Dhakeshwari Cotton Mills. 26 ITR 775 is the citation. 26 ITR 775. Article 136. Now, my point of view is this, that Article 136 is a provision which is giving in the Constitution of India the power to the Supreme Court to admit any SLP against any order of an High Court or the tribunal concerned, where Supreme Court finds it worthy to interfere. Now, where they do test of perversity is the test. Test of perversity. Are you noting it? Now, what do you say, Deepak bhai, is perverse?
Which is blatantly illegal, totally.
Sorry, come back to Article 14 for the moment where you written in Article 14. Please note this point also. Something will offend Article 14 which is perverse and which is disproportionate. I forgot, sorry. Article 14 of Constitution of India nowadays have been also interpreted by the Supreme Court. The test of proportionality and test of this, what I was saying, perversity will be read into the Article 14. Are you getting my point, Deepak ji? Now, I give an example in income tax law as 115 BB. I was saying something which is absolutely disproportionate. Let us say 1 rupee is the income escaping assessment. You made it 100. There can be cases where department has acted in a disproportionate manner in a particular matter. So, test of proportionality has been read into our constitution in Article 14 by the Honorable Supreme Court in various cases. I am giving you the brief point. So you please note Article 14 के अंदर proportionality भी आता है और जो perversity है वो भी आता है. I hope you have noted it down. So Article 14 and 21 हो गया. Article 136 का अभी बात कर रहा था कि Article 136 में Supreme Court will use its power of SLP. Generally, sometime on lighter side we say it is a special luck petition. So it's special leave petition. It's not like that. So, but yes, you go to Supreme Court, they have hundreds of matter, my lords. They are sometimes, see, admission is a tricky task in SLP. It's not that easy. Generally, Supreme Court, it's a judge to judge approach again. So, Article 136 I have cleared. The जितना आपको बताना था, अभी आगे बढ़ता है. Article 141. This is also very, very important, Deepak Bhai, for the tax professionals to know. Article 141 says law declared by the Supreme Court shall be binding across India. Now it is Article 141 में क्या है? Law declared by the Supreme Court. Now what is law declared by the Supreme Court, Nikhil Bhai? Something where the Supreme Court says this is the law. And this is the, what do you say, there is a neat proposition of law laid down by any judgment. Now, any observation of the Supreme Court casual will not be law declared. Sorry. Article 141 says law declared by the Supreme Court shall be binding. So, we say generally, mere SLP dismissal is not law declared. Simpliciter SLP dismissal by the Supreme Court is not attracting binding force of Article 141 of the Constitution. Yes, if Supreme Court lays down any law, it does not matter in whose favor it is. Now, it will be very, very furious if some assessing officer is allowed or some income tax officer says, I will not follow what Supreme Court has said. And we have seen that happening. Deepak ji, we have seen department in the income tax, especially when it comes to assessee favoring orders. We have seen those kind of adjudications and assessments where Supreme Court orders are also breached. That's a serious case of judicial indiscipline. That's a serious case where you can go to the High Court, directly to the High Court for interference in the Article 226. If some assessing officer passes an order which is directly in conflict with the Supreme Court order and Supreme Court order has been breached, then you can approach the High Court under Article 226 for interference in the writ jurisdiction. So you must know as a representation कि जब आपको जाना होता है तो आपको पता होना चाहिए सब संविधान में लिखा हुआ है. This is not matter of joke for the department that department can create litigation for the sake of litigation and keep litigation throwing on the head on the head of the taxpayers like this. And Deepak Bhai, see the fate of litigation, face of litigation or the image of litigation. I see 90% of litigation, majority of the litigation is somewhere again centered on this point. The department is not ready to accept those decisions where it has lost.
Yes.
If I'm not wrong, sir.
Definitely, sir.
The engineering analysis software royalty decision, they have lost. Still, they are wanting to dig that grave which they already digged. Engineering analysis software royalty issue has been a popular issue, and Karnataka and Bangalore has been the point where it came. And Abhi Nikhil Bhai was talking about one transfer pricing case of brands, and Justice Vineet Kothari was the author of that order. Now Justice Amar Shah has reserved it. Now point is this, Nikhil Bhai, see, I'm nobody. See, again, we are discussing in a student of law manner. What is this going on? I don't know. Litigation after litigation. Sometimes I feel these people are creating litigation only for the lawyer's paradise. I can't say chartered accountant's paradise. It's a lawyer's paradise. With due respect to some friends of me, might sometimes take an offense out of it. Yaar Goel sahab, aapko to kaam hi mil raha hai isi cheez se. Aap kyun bol rahe ho yaar? Nahi bolte zyada sir. But I am telling you, the litigation has its own, what do you say, rules of game. And department is, we see GST litigation, we see income tax litigation. Why Deepak Bhai department does not want to understand the simple and basic thing of principle of natural justice, which is so much of ingrained into our jurisprudence and constitution? Why it is so hard to explain to them that this is our basic right, inviolable right? Why for these things also we have to go to the high courts? That is the point. Article 136, sorry, I have told you, Article 141, we were discussing law declared by the Supreme Court shall be binding. If assessing officer dares to pass an assessing officer, we have seen Deepak Bhai in one of the recent cases where an assessing officer in the income tax law, must be आप लोगों ने भी देखा होगा, आज तक पे भी आया था कि अभी लेटेस्ट की बात है, पिछला 2-3 दिन पहले का, कि इलाहाबाद हाई कोर्ट का लखनऊ बेंच के सामने एक DCIT था इनकम टैक्स का, उन्होंने कोई इलाहाबाद हाई कोर्ट का ऑर्डर, प्रशांत चंद्रा का केस है, नोट कर लीजिए, एडवोकेट सावेन का एक केस था, प्रशांत चंद्रा वर्सेस DCIT, मिस्टर गिडवानी समथिंग. तो उन्होंने इलाहाबाद हाई कोर्ट का इनकम टैक्स का फैसला इनका फेवर में था, क्वेश्चन का, उसको मानने से कुछ ऐसा कर दिया, नहीं मैं मान रहा. तो 7 days का imprisonment जेल किया है को. This has come on Aaj Tak, national TV channel also. So you can note the name if somebody wants to name. Note. आप कहेंगे तो Mr. Goel, are you advising us to take action under the Contempt of Courts Act against this assessing officer? You take a call. I'm not saying anything to you in that manner. You calculate your points, you calculate your position, and accordingly move forward. And Deepak bhai, but yes, we should be aware that there is a Contempt of Courts Act provision, and courts are serious about it. Some judges are very, very particular about it. I'm telling you. So somebody, assessing officer is there, he's a daredevil, he does not want to follow what Karnataka High Court is saying for Karnataka jurisdiction or Supreme Court has said for the India, then he can be in a serious trouble. If somebody takes them even under a Contempt of Courts Act for violating judicial discipline. Anyhow, Article 136 I have told you, Article 141 I have told you. Article 141 you can note down. Generally, it creates confusion in the minds of tax professionals and tax judges also sometime in the ITATs. That we can say, ki, sir, only those decisions of Supreme Court have binding force where the law is declared as such. Mere dismissal of SLP and simplicity in limine dismissal does not create binding. Yes, if there is otherwise, and every decision has to be read in a manner. See, Deepak bhai, in the courtroom, in the law practice, which you have called me today to speak on a practical point of view, one thing which we are now, and अभी क्या होने लगा है दीपक भाई, of lately you will appreciate, कि इतना सारा precedent आने लग गया है कि हम लोगों को confusion हो जाता है. It's a labyrinth. भूल भुलैया एक फिल्म है ना, भूल भुलैया. It's a labyrinth, I say in English. So how you come out of that labyrinth of the case law? I can just give you 1-2 tips you can note down. Because I was discussing Article 141, what decisions are, precedents are. Precedent way you have to have always, Deepak bhai, you will appreciate 2 points. What is ratio of a decision, principle emerging from the decision, and what is not principle. अभी सुप्रीम कोर्ट ने इतना जजमेंट इसी बात पे दिया है दीपक भाई कि कैसे प्रेसिडेंट को पढ़ना चाहिए, कैसे उसमें से प्रिंसिपल रेशियो निकालना चाहिए. रेशियो मींस प्रिंसिपल जो उसका बाइंडिंग फोर्स जिस पे लगेगा, और एक ऑबिटर लिखता है, एक कैजुअल ऑब्जर्वेशन है जिसपे नहीं लगेगा, जिसको बाइंडिंग फोर्स नहीं माना जाएगा, परसुएसिव वैल्यू. तो व्हाट इज हाउ यू गेट इनटू द रेशियो ऑफ ए डिसीजन इज एन आर्ट. अभी आपको किसी कोर्ट में आर्ग्यू करना है और अभी आपका एम्प्लॉय प्रोविडेंट फंड का झगड़ा चल रहा है जो हमारे को सबको बड़ा क्या बोलते हैं, अभी आपका मुस्कुराहट आ गया. देखिए वो क्या झगड़ा है, झगड़ा अजीब सा झगड़ा है. वो झगड़ा ये है कि 143 सबसेक्शन 1 के अंदर एम्प्लॉय प्रोविडेंट फंड जो हमने उस लॉ का ड्यू डेट के बाद जमा कराया उसको डिसअलाउ कर दिया. कर्नाटका हाईकोर्ट का लीडिंग जजमेंट था सबरी एंटरप्राइजेस उस जमाने का, जिसको अभी सुप्रीम कोर्ट ने किस्म से ओवररूल कर दिया चेकमेट का केस में. 444 आप नोट कर सकते हैं, 448 आईटीआर चेकमेट सिक्योरिटी लिमिटेड, 448 आईटीआर पेज नंबर 518, 448 आईटीआर पेज नंबर 518. Now question comes ki Deepak bhai, whether this judgment can be treated as a precedent for the point that what comes in the scope of 143(1) and what does not come in the scope of 143(1). I have just said that any law declared by Supreme Court is binding across India. Yes. Checkmate decision of Supreme Court by Justice Ravinder Bhatt is binding across India, no doubt. But whether it is a ratio, whether it is a principle, that 143 subsection 1 adjustment can be done for something as debatable, as contentious as on that date. Co-op employee provident fund. What is your answer, Deepak ji?
Certainly no, sir. It's not a ratio on
and
143.
department and department ko dekhiye Deepak bhai aur tribunal ke with due respect to our members, honorable members, with due respect to them, sir, with all respect, how this judgment is cited and used now. Now department is treating it as a bible, or in the sense that is judgment ke base pe जो 143 सबसेक्शन 1 है उसका स्कोप भी डिसाइड हो गया. हाउ इज दिस? वो तो क्वेश्चन ही नहीं है उसको जजमेंट में. आपने ये कहां से निकाल लिया कि 143(1) का इश्यू सुप्रीम कोर्ट के सामने था और उसमें कोई प्रिंसिपल ऐसा ले डाउन किया है? ये आपने नोट कर लिया. इन माय ओपिनियन चेकमेट सिक्योरिटीज डिसीजन ऑफ सुप्रीम कोर्ट कैन नेवर बी अप्लाइड ऑन द इश्यू ऑफ स्कोप ऑफ परमिसिबल एडजस्टमेंट बाय सीपीसी इन 143. एंड दिस आई एम सेइंग ऑन वेल सेटल्ड जजमेंट बाय सुप्रीम कोर्ट. कॉन्स्टिट्यूशन बेंच का ऑर्डर्स है कि आपको प्रेसिडेंट को कैसे पढ़ना चाहिए. इसको एक ही लाइन में लिखवा सकता हूं. निखिल भाई आप सब जहां लिख रहे हैं एक लाइन लिख लीजिए, बड़ा काम का लाइन है, आपके कोर्ट में हमेशा काम आएगा. ए डिसीजन इज एन अथॉरिटी फॉर व्हाट इट लेज डाउन. Decision is an authority for what it decides, and for what it does not decide, it cannot be an authority for that. Am I there, sir? An authority, see, a decision precedent is an authority for what it actually decides. For what it not decide, you cannot say it is an authority for that also. That is a punchline. That is a summary of 100 of decisions of Supreme Court. Still, I will tell one decision, Deepak Bhai, I really love to read it. It was written by, although this Judge Saab has taken voluntary retirement, he's from South. You must be knowing, is Dama Sheshadri Naidu Saab has been one of the judge in Bombay High Court in Nagpur bench. He has written one income tax wala फैसला आपने पढ़ा होगा सबने. That is regarding that penalty का show cause notice में उन्होंने tick mark नहीं किया, inaccurate particular, concealed particular. That is a decision of Mohammad Farzan. You can note this decision. This decision is written by this great judge, where he has, it's a 3-judge bench order, full bench order of Bombay High Court, Goa bench, where for any person who is youngster here, or for any person who is a law lover, who wants to go to the deep of the law lover, I should use the phrase not youngster, law lover. Then people can say, you are not youngster, Mr. Goel. I am youngster. So I am saying it's the decision is for law lover who want to get into the deep of the law. What he has done, Nikhil Bhai, in this decision, Judge Saab has made an extraordinary research. कि किसी को आप प्रेसिडेंट बोलते हैं, किसको रेशियो बोलते हैं, किसको ऑबिटर बोलते हैं, सारा काम 434 ITR पेज 1, नोट इट डाउन. So worth reading. 434 ITR page 1, Bombay High Court full bench, Goa bench, Justice Dama Sheshadri Naidu, Mohammad Farzan, 434 ITR page 1. Am I there, Deepak Bhai? 434 ITR page 1. You must read it, all of you. That आपको कैसे पता चलता है कि आप कौन सा प्रेसिडेंट का हिस्सा को या पोर्शन को रेशियो मानते हैं और कौन सा को पोर्शन को निखिल भाई रेशियो नहीं मानते. इसमें जमीन आसमान का फर्क आ जाएगा सर. अगर हमने इस पे गलती कर दिया है तो सब कुछ गलत हो जाएगा. अब सी द पॉपुलर दीपक भाई पॉपुलर सेंस ऑफ ए डिसीजन गोज लाइक दिस, कि जिसके फेवर में जो डिसीजन आता है वो उसको स्ट्रेच कर रहा है. इट्स ए पॉपुलिस्ट सेंस ऑन बोथ साइड्स, एसएससी साइड आल्सो एंड डिपार्टमेंट साइड आल्सो. But that is not the healthy way of reading a judgment, objective way of reading, a balanced way of reading a judgment. We have to be careful in culling out the principle and ratio decidendi of an order. Ratio decidendi emerging from 434 ITR page 1. Anyhow, I told you how to read a judgment. NRA iron has been applied out of proportion by department anything. NRA iron, you know, sir, that 68 wala faisla. Now that was a typical share capital case where the companies are found to be non-existing on the address. Then adverse inference was drawn under 68, upheld by the Supreme Court Justice Indu Malhotra. Now this judgment is used like a carte blanche. In every case of 68, department uses this like a blank check and carte blanche. This is not the way you can read any dictum. And that is why I have to devote so much of energy and time to explain you that when you are in courtroom, when any precedent comes, you have to be very, 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 very careful how you call out the principle and how you decide that what is ratio decidendi and what is not ratio decidendi. I hope I am clear on this, sir. Now, what I was saying, Article 141 ho gaya, sir. Yes. Now comes Nikhil Bhai, Article 226, my favorite article, my bread and butter, my main building place. अभी हमारे पास इतना रिट पिटीशन आने लग गया इनकम टैक्स का 148 का. अभी अपील का काम तो कम कर दिया हम लोगों ने, क्योंकि हम अभी आर्टिकल 226 पे ही काम कर रहे हैं. और देखिए बढ़िया लोग हैं, सॉरी मैं ऐसा बोल रहा हूँ अपने लिए हम अग्रवाल हैं. अभी क्या करेंगे, जिसमें ज्यादा धन मिल रहा है, अभी काम मिल रहा है, पैसा मिल रहा भी है, तो ये मैं लाइटर साइंस में बोल रहा हूँ, बड़ी विनम्रता से बोल रहा हूँ लाइटर साइंस पे, कोई इसको हार्ड साइंस से ना ले. क्योंकि कई और कुछ लोग कहेंगे यार आप तो गोल साहब बताइए, आप खुद अग्रवाल होकर ऐसा कैसे बोल रहे हैं, आप ऐसा कैसे बोल रहे हैं पैसे के बाद. मैं ऐसा इसलिए बोल रहा हूँ मजाक के लिए, साहब सोचते हैं कि अभी आर्टिकल 226 ही पढ़ते रहे, आर्टिकल 226 ही पढ़ते रहे, इसी में माँ लक्ष्मी की कृपा हो रही है, माता लक्ष्मी आशीर्वाद दे जा रही है, ली पढ़िए पढ़िए पढ़िए. और बहुत सारे लोगों ने तो मेरे से प्रोत्साहित होकर सीए का वो सीओपी का सरेंडर करके रिस्पेक्ट दीपक भाई आर्टिकल 226 का काम करना चालू कर दिया. आप कहेंगे गोयल साहब आप इसका मतलब हमें भी ये कह रहे हैं क्या. मैं किसी को कुछ नहीं कह रहा हूं, मैं आपने मेरे को अनुभव अपना बताने के बोला, मैं बता रहा हूं. मेरा बात समझ में आ गया सर. आर्टिकल 226 सर निखिल भाई, व्हाट ए प्रोविजन इट इज. हैट्स ऑफ टू कॉन्स्टिट्यूशन मेकर सर. समथिंग व्हिच इज डोंट नो. एक दिन मेरे स्कूल के जहां मेरा बेटा पढ़ता है दीपक भाई, अच्छा आज एक और बात बताता हूं आप सबको. आई मस्ट टेल यू, आई एम सॉरी आई फॉरगॉट इट. टुडे माय एल्डर सन मिस्टर, मेरा जो बड़ा वाला बेटा है अर्नव गोयल, उसका जन्मदिन है सर. तो वी आर सेलिब्रेटिंग हिज बर्थडे टुडे. ही इज बिकम 11 इयर्स. तो आप सबका आशीर्वाद उसको मिलेगा, आई होप सो. तो एक दिन अर्नव के स्कूल में मुझे बुलाया निखिल भाई बोलने के लिए, वैसे ही उनके प्रिंसिपल में कि मिस्टर गोयल यू आर ए बडिंग लॉयर, यू शुड टेल अस आवर स्टूडेंट्स। तो मैंने कहा कि मैं कॉन्स्टिट्यूशन पे बोलूंगा। तो मेरे को ये लगा सर कि हमारे संविधान, और अभी जब कॉन्स्टिट्यूशन डे था, हमारे प्रधानमंत्री और हमारे राष्ट्रपति जब आए थे तो उन्होंने भी बोला कि संविधान को हर एक आदमी को पढ़ना चाहिए। यंगस्टर्स के लिए तो उन्होंने ज्यादा बोला। दीपक भाई आपको याद है बात, अभी प्रधानमंत्री साहब जब दिल्ली में कॉन्स्टिट्यूशन डे पे आए हुए थे, चंद्रचूड़ साहब वगैरह सब लोग वहां थे, तो आवर ऑनरेबल प्राइम मिनिस्टर, बिलव्ड प्राइम मिनिस्टर मिस्टर मोदी सेड देयर दैट एवरीबॉडी शुड, खासकर यंगस्टर्स के लिए उन्होंने ये कॉल दिया कि साहब कॉन्स्टिट्यूशन शुड बी मेड कंपल्सरी टू देम टू रीड एंड अगेन। Anyhow, I was finding this article 226 very special, Nikhil bhai. Boring तो नहीं लग रहा है Nikhil भाई? I'm
not at all. Not at all, sir.
तो आर्टिकल 226 में ऐसा क्या स्पेशल है दीपक भाई कि जो मैं बोल रहा हूं कि इतना जबरदस्त आर्टिकल है? सर सोचिए दीपक भाई, अगर मान लीजिए ये रिट पिटीशन, इसको हम बोलते हैं पॉपुलरली रिट पिटीशन, इसी आर्टिकल में फाइल होता है, हाई कोर्ट के सामने जाता है। एवरी हाई कोर्ट इन द कंट्री has been given a special power by the constitution makers, wide article 226 and wide article 227. This is a special power of superintendence of high courts across their territories कि वो अपने authorities को कैसे लॉ के अंदर बाउंड रखे। ये आर्टिकल 226 और आर्टिकल 227 है, जिसकी महिमा जितनी गाई जाए उतनी कम है। जैसे राम जी की महिमा जितनी गाई जाए उतनी कम, भगवान कृष्ण की महिमा जितनी गाई जाए उतनी कम, उतनी आर्टिकल 226 की महिमा गाई जाए उतनी कम। मैं आपको सीरियसली बोल रहा हूं दीपक भाई, मैंने पिछले कई महीनों में, ये तो एक लाइटर बात थी कि मेरे पास काम आर्टिकल 226 का बहुत ज्यादा आ रहा है तो मुझको पढ़ना भी पड़ता है, बट मैं अपने अध्ययन की आपको एक बात बताना चाह रहा था कि मैंने इतनी किताबें आर्टिकल 226 की निकली भाई पढ़ी, क्या सर उसमें कंसेप्ट हैं सर। मतलब अगर आप टेक्स्ट जूरिस्प्रूडेंस को तो बहुत पीछे रह जाता है, सारी जूरिस्प्रूडेंस तो आर्टिकल 226 से निकली है सर, ऐसा लगता है। मतलब majority of best concepts of jurisprudence has come from the jurisprudence laid down in article 226. What is this power about? This power is this कि that constitutional power है, constitutional courts के पास है, high court के पास है कि आप किसी भी authority के किसी भी decision के खिलाफ high court जा सकते हैं, provided there is a question of law, no disputed question of fact. आप नोट कर लीजिए, जनरली हम कहां जा सकते हैं आर्टिकल 226 में, जहां प्योर क्वेश्चन ऑफ law, no disputed question of fact, जहां serious violation of natural justice, serious violation of principles of natural justice या question of jurisdiction. Supposingly any assessment is made by any authority, any show cause notice is given by any authority which is absolutely without jurisdiction on the face of it. Are you noting Deepak bhai? For tax professional point of view, from chartered accountant's point of view, what is you have to keep in mind while advising your client whether it is a fit case to try writ or no writ? You can note down 3-4 points quickly. If it is a case of gross violation of principle of natural justice, अब आप कहेंगे इसमें क्या आता है, लिख लीजिए क्विकली। ग्रॉस वायलेशन ऑफ प्रिंसिपल ऑफ नेचुरल जस्टिस में मतलब वेग शो कॉज नोटिस, नो इनवैलिड शो कॉज नोटिस, इनवैलिड वेग शो कॉज नोटिस, नो अपॉर्चुनिटी ऑफ पर्सनल हियरिंग, ओरल हियरिंग, नॉन कंसिडरेशन ऑफ रिप्लाईज फाइल्ड बाय द असेसी, back material not supplied. All these are violation of variants of natural justice. You know na variants, corona variant we are discussing, so that is another thing. So there are variants of natural justice violations. I noted it down like this: one, where there is no proper valid show cause notice, where there is no oral hearing given to the taxpayer, when the back material relied against the assessee is not supplied and confronted to him, sir, when the reply and submissions filed by him are not considered, adequate opportunity and reasonable opportunity is not given. Time given is 1 day, 2 days, 48 hours, like that. So Nikhil bhai, this is a very important area where we see many of the writ petitions filed in the tax cases in the CA practice in the high courts are on the area of violation of principle of natural justice, PNG. That is one part. Justice Krishna Dikshit is a wonderful judge in Karnataka High Court. I have read his orders. What his lordship writes, sir. He has also written in order in the case of Wipro Limited, 438 ITAT somewhere. What's reading order? What an order it from Article 226 beautiful point of view. So what I am saying is, Deepak bhai, Article 226 principle of natural justice area is, see, many CAs and many courts, many times we get this confusion कि sir alternate remedy में जाना अच्छा है या writ में जाना अच्छा है. Writ remedy is a better remedy for those cases where you feel that there is a serious violation of principle of natural justice, and you can convince the court to come back, remand back, or the case can be set aside and quashed by the court. Are you getting my point, sir? So you are you have a Deepak ji, the point of today's seminar, before I forget it, just as I say, na, you always should have a habit when you go to the court, try to make a distillation and filtration of disputed facts and undisputed facts. That's a very important point. Now, second thing I'm telling you a tip is, we should try to inculcate a habit that we can pitch our case in that sense, Nikhil ji, where we can prick the conscience of the judge. आपको जज की कंसेंस को हिलाना है कि देखिए सर इतना अन्याय हो रहा है, तो न्याय कैसे मिलेगा? मतलब यू हैव टू प्रिक द कंसेंस ऑफ द जज टू गेट द जस्टिस. यू हैव टू मेक आउट योर केस इन दैट मैनर. सी दिस फ्रेज इज वेरी मेनी टाइम्स. मैंने क्या सीखा सर कोर्ट से भी, दीपक भाई, ज्यादा रिट का कोर्ट का प्रैक्टिस करने में एक बहुत अच्छा चीज मैंने सीखा, लर्न किया माय लॉर्ड से, कि वी हैव टू हैव ए वेरी गुड हैबिट. हाउ वी कैन हैव इट कि साहब how you should make out a case. Making out a case, आप लिख रहे हैं what? Make out a case. Make out a case before the court which you are going. How you make out? लिख लीजिए इसका टिप फटाफट क्विकली. मैं आर्टिकल 226 पे था, प्रिंसिपल ऑफ नेचुरल जस्टिस की बात कर रहा था. आई एम जस्ट डाइग्रेसिंग. How you can make out a case for the judge court to interfere in your favor. Try to show where the justice lies in your favor. Try to bring him to that justice in your favor. Justice is in your side. Are you getting my point? Justice is in your side, assessee side. How you can do that? You have to present the facts and point out the particular pointed facts which shows high-handedness and the extraordinary sense of irresponsibility behavior of the departmental officer. Are you getting my point? That is what we learn in court, sir, with the healthy net. That's the beauty of court practice. You have to make out a case. You have to show justice to your side. You have to bring the court that they have to interfere because there is a case made out. How you say case is made out? Deepak bhai, it's a challenge. When you make out a case, you win. When you don't make out a case, you are out of the courtroom. You say, Mr. Goel, how can we make out a case? I'm telling you with all force. You have to bring proper facts and note down this. What are the facts? Classical facts of your case. Note it down. Classical facts, law applicable, legal preposition, then you make out a case. Arrange your case in such a manner. Arrange your case in such a manner that classical facts of your case, legal provision involved, preposition of law, and relief claimed. These all should be knitted, weaved together. Facts, legal provision, preposition of law, and relief claimed, and prayer for the relief. These all should be made properly. I should repeat, Nikhil bhai, facts of the case. When I say facts, Deepak bhai, facts means foundational facts. I don't know how many of you appreciate the difference between foundational facts and the facts per se. What are foundational facts, Nikhil bhai, Deepak bhai? What are foundational facts? Foundational fact बहुत important है sir. Foundational fact को हम essential facts भी बोलते हैं. हमें वो हैबिट लाना चाहिए निखिल भाई, जिन फाउंडेशनल फैक्ट्स पे पूरा केस है उसको, जैसे क्या कहते हैं, शेफ को ग्रेन से हम सेपरेट करते हैं, मिल्क को सेपरेट करते हैं, तो ऐसे आपको फाउंडेशनल फैक्ट्स को निकालना है. नोट कर लीजिए वर्ड फाउंडेशनल फैक्ट्स. फिर उसके बाद लीगल प्रोविजन कि कौन कौन सा प्रोविजन एप्लीकेबल है. फिर उसके बाद केस लॉ पे आइए, प्रपोजिशन पे आइए. पहले फैक्ट्स, फाउंडेशनल फैक्ट्स, फिर लीगल प्रोविजन, स्टैट्यूटरी प्रोविजन, फिर लीगल प्रेपोजिशन और फिर प्रेयर. और इसमें कॉन्स्टिट्यूशन ऑफ इंडिया को भी आप फिट कर सकते हैं जब आप प्रेपोजिशन की बात करें. आर यू गेटिंग माय पॉइंट? सो दिस इज हाउ यू कैन नीट योर अपील ड्राफ्टिंग कि आप फाउंडेशनल फैक्ट्स भी लाएं स्टेटमेंट ऑफ फैक्ट्स के अंदर. देयर इज अ स्टेटमेंट ऑफ फैक्ट टू बी फाइल्ड टू द CIT appeal. And there is a ground of appeal you have to make. Ground of appeal make like a question of laws, proper neated questions, crystallize issues. अच्छा, कई बार क्या होता है दीपक भाई, इन टैक्स प्रैक्टिस वी डू नॉट हैव दैट थिंग ना. जैसे सिविल लॉ में तो इश्यूज को बनाना बहुत जरूरी है. हमारे यहाँ इशू नहीं बनता है इनकम टैक्स में से, पर आपको मैं बता रहा हूँ क्वेश्चन ऑफ लॉ और इशू बनाने का बड़ा फायदा है कि इशू फॉर कंसिडरेशन क्या है, समथिंग लाइक ग्राउंड ऑफ अपील. तो फाउंडेशनल फैक्ट हो गया, इश्यूज फॉर कंसिडरेशन हो गया, लीगल प्रोविजन हो गया, लीगल प्रेपोजिशन हो गया, और प्रेयर और रिलीफ हो गया. 5 चीजें बता दिए, 5 तत्व हो गया. 5 तत्व दोबारा बताएं. फाउंडेशनल फैक्ट्स, दूसरा क्या है?
Legal provisions.
नहीं सर, उससे पहले issues for consideration, legal provision, फिर उसके बाद लीगल प्रेपोजिशन और सबसे लास्ट में रिलीफ एंड प्रेयर. Am I with you सर? क्लियर हो गया? तो चलिए, ये मैंने आपको आर्टिकल 226 की बात कर रहे थे, उसमें मैं बता रहा था दीपक भाई कि कौन कौन से एरियाज हैं जहां आप रिट पिटीशन में डायरेक्टली जा सकते हैं असेसमेंट के खिलाफ. One is area of principle of violation of natural justice. Second is where jurisdictional questions are there. Note it down. Jurisdiction बहुत इंपॉर्टेंट है सर. आप देखिए, जैसे फॉर एग्जांपल 179 में डायरेक्टर की रिकवरी के खिलाफ कोई अगर आपको बोल दिया कि कोर्स इनडायरेक्ट रिकवरी के लिए, वाइकेरियस लायबिलिटी के लिए, और बिना कंपनी को रिकवर करे हुए डायरेक्टर पे आ गया डिपार्टमेंट सीधा 179 के अंदर, जैसे वो कौन सा स्ट्राइक ऑफ कंपनीज में होता है, तो वो गलत है. आपको 179 सेक्शन का जुडिशियल फैक्ट पढ़ना पड़ेगा कि if money cannot be recovered from the company, then you can come to director, but a department has to show what steps they have taken to recovery against the company. Are you getting my point, sir? So writ petition is a very important provision where we can advise our client to go to High Court in A, areas of violation of principle of natural justice. B, question of jurisdiction. Now, jurisdiction is a very important word, Deepak bhai. Many times you don't understand where the jurisdiction comes from. If jurisdiction is lacking, jurisdiction is the authority, the provision which gives authority, the point, fact, issue which gives authority. If that is lacking in a case, then you can go to the High Court for want of jurisdiction. And third, question of constitution, violation of fundamental rights. Just I have told you Article 40, 19 and 21. Then also you can approach the High Court directly. So three things I have told Nikhil bhai: violation of principle of natural justice, violation of question of jurisdiction, and third, violation of fundamental rights. You can approach directly the High Court under Article 226 without going to the alternate remedy. There are hundreds of decisions on this issue, but I will tell 3 decisions you can note down. Important decision on Article 226 because it's a very important area nowadays of legal practice. One is Calcutta discount case of 5-judge bench, 41 ITR 191. 41 ITR 191. Constitution bench decision. Scope of writ remedy before High Court, Article 226. Leading law. Very famous decision, Deepak bhai, Calcutta discount limited. 41 ITR 191. Scope of writ remedy before the Honorable High Court. The latest decisions may आप note कर सकते हैं, Magad Sugar Limited. It is by Dr. Chandrachud. Magad Sugar Limited versus State of Bihar. This is a 3-judge bench order of Supreme Court of India, Magad Sugar Limited, by the bench of Justice Dr. Chandrachud, D.Y. Chandrachud. That is a leading law where all decisions concerning scope of Article 226 has been beautifully covered by Honorable Lordship Justice Chandrachud Saab, who is now the current Chief Justice. He has said that where there are pure question of laws, pure jurisdictional issues, even if alternate remedy is there, you can directly approach the High Court. And third decision, which I have discussed in many seminars, I will just repeat: Radha Krishna Industries versus State of Himachal Pradesh. It's a GST law order. Radha Krishna Industries versus State of Himachal Pradesh. So I have to tell you, Article 226 is an important area of practice for even from CA perspective in this manner, Deepak bhai. We have to advise our client ki sab whether or not to go and at what stage we can go for Article 226. Can I go further now, sir? Article 226 and 227 I have broadly touched. Now comes, Deepak bhai, the point of Article 265 and 300A. Please note it down. Article 265 must be always on your lips. It says no tax can be collected and levied except by authority of law. That is, for any collection, any levy of any tax, there has to be proper authority of law. And without any authority of law, you cannot collect and levy any tax. So kindly see in how many tax assessments and tax adjudication they are with authority of law. In how many cases Article 265 Atma is not breached. In how many cases department is fulfilling Article 265 mandate and dictum. Article 265 is again one of those provisions which we see very commonly and ordinarily not being followed, Deepak bhai. No tax can be collected and levied except by authority of law. It should come in your pleadings. Now Article 300A. Article 300A says that nobody can be deprived of its property without proper procedure of law being followed. Supposingly your provisional attachment takes place under the Income Tax Act, but the norm given in the law statute is not fulfilled, then it is a violative of Article 300A. something is arbitrarily seized, something is arbitrarily confiscated, something is arbitrarily attached, then you can go to Article 300 capital A. I hope this completes the chain of the important articles which I have to tell to my viewers, which you can use in day-to-day practice. Out of this, I give you another quick recap. Article 14, right to equality, arbitrariness wala point. Article 19, freedom, rights, and right to business on and all this reasonable restriction. Article 21, right to liberty and life. Article 136, Article 141. Article 136 was specially petition. Article 141, binding law, how to read a precedent. Article 226, writ power, 226 and 227. And then Article 265 and 300. See, Deepak bhai, how much time it took. But I have to make it clear because I know when we make submissions and representation, and in that I also tell you how to distinguish between disputed facts and undisputed facts. How to go to foundational facts. How to go to legal provision and coalesce it with how to go to the issues for consideration. How to go to the prayer make. See, many times the relief and prayer which we make is not proper. So you have to work on prayer and relief claimed also on a proper point. Supposingly, I want to say reopening proceedings should be dropped, should be terminated, should be filed. So there should be a proper, I was reading somewhere, there should be 3 things present in our drafting, Nikhil bhai, if you want to note down in our presentation. One is method, second is arrangement, third is order. Method, arrangement, order. I believe अगर आप में से हम में से किसी ने भी इसको समझ लिया तो रिप्रेजेंटेशन तो आपका सर बहुत अच्छा हो जाएगा. दीपक भाई, method, arrangement and order. These 3 things when you go for any courtroom pleading or any pleading in any case, you have to have proper method in your pleading, representation, you have to have proper arrangement, you have to have proper order. जैसे let me take order first. कि order का मतलब sequence. दीपक भाई, मेरे को कई बार ऐसा लगता है कि जब हम कोर्ट में आर्ग्यू करते हैं, ट्राइब्यूनल में जाते हैं, तो उसमें सबसे बड़ा इंपॉर्टेंट पॉइंट इस बात का रहता है कि ओपनिंग स्टेटमेंट क्या हो. आप समझते हैं ना ओपनिंग स्टेटमेंट का मतलब? ओपनिंग स्टेटमेंट मतलब वो वाला पॉलिटिकल स्टेटमेंट नहीं. ओपनिंग स्टेटमेंट मींस कि हाउ टू ओपन द आर्ग्यूमेंट. और उसी में लिख लीजिए, मैं आपको बताने वाला हूं बड़ा. अब हम फिल्म के क्लाइमैक्स में आ गए, आधा घंटा. हाउ टू ओपन द आर्ग्यूमेंट एंड हाउ टू क्लोज द आर्ग्यूमेंट. आप बताइए कैसे करेंगे आप? अगर आपको एक केस स्टडी दी जाए कि साहब आपको ये केस ट्रिब्यूनल में आर्ग्यू करना है जिसमें आपका सर्च असेसमेंट का एक इशू है और 153 153 का सर्च असेसमेंट का, और उसमें कोई इंक्रिमिनेटिंग मटेरियल नहीं मिला है और कर्नाटका हाईकोर्ट का दिल्ली इंटरनेशनल एयरपोर्ट वाला फैसला से कवर्ड है.
फर्स्ट 30 सेकेंड्स 1 मिनट के अंदर पूरा ब्रॉड कैप्चर होके कोर्ट शुड बी कन्विंस्ड दैट दिस इज समथिंग व्हिच इज ऑलरेडी कवर्ड.
ये बहुत अच्छा बात आपने बोला. आई विल, यू वेरी राइटली सेड. इसका पर्पस ये हुआ दीपक भाई की एक जगह मैंने सीखा कि एक तो प्लीडिंग का आर्ट होता है कि आप सिनॉप्सिस जरूर कैरी करें, नोट कर लें. ट्राई टू डेवलप ए शॉर्ट सिनॉप्सिस. ऑलवेज 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 शॉर्ट सिनॉप्सिस. शॉर्ट सिनॉप्सिस का मतलब नहीं थीसिस. शॉर्ट सिनॉप्सिस में क्या आएगा? फिर वही बात, ब्रीफ फैक्ट्स, फाउंडेशनल फैक्ट्स. आपका कौन से पेज पे एओ का ऑर्डर में क्या लिखा है, सीआईटी अपील का कौन सा पेज पे क्या लिखा है, आपका ग्राउंड ऑफ अपील क्या है, आप समझते हैं. और उसमें आपका लीगल प्रोविजन कौन कौन सा इन्वॉल्व है, केस लॉ कौन कौन सा आप रिलाई कर रहे हैं. ऐसा शॉर्ट सिनॉप्सिस, रिटन सिनॉप्सिस जरूर कैरी करें आप समझ रहे हैं. जब आप वर्चुअल हियरिंग सीआईटी अपील पे भी अटेंड करते हैं तो मेरा हमेशा रिक्वेस्ट है, चाहे फेसलेस असेसमेंट में कर रहे हैं, आप नोट कर लीजिए कपिल गोयल्स केजी सजेशन. ट्राई टू डेवलप ए गुड सिनॉप्सिस, शॉर्ट सिनॉप्सिस. इट विल ऑलवेज गिव यू एज इन योर प्लीडिंग. फिर उसको आप बार बार उस पे सी, जो मैं किताब बोल रहा था बिफोर द मेमोरी फेड्स, इसमें एक बात मैंने सीखी नारीमान साहब से सर, कि जितना केस को एक तो आप होता है रिटन नोट कर रहे हैं, सिनॉप्सिस बना रहे हैं, वो तो अच्छा बनाना ही है, उसके बारे में चिंतन भी करना है आपको. यू हैव टू थिंक ऑन योर केस. समटाइम ओरल थिंकिंग इन योर माइंड ऑफ ए केस गिव्स यू ए स्पेशल कमांड. नोट, आप क्या करेंगे जब भी केस आर्ग्यू करने जाएंगे, प्लीड करने जाएंगे, तो आपको सिनॉप्सिस डेवलप और उस केस के बारे में आपको मनन करना है, चिंतन करना है. मनन समझते हैं, इंग्लिश में बोलेंगे उसको डीप थिंकिंग, कॉगिटेटिंग. यू हैव टू कॉगिटेट ऑन द केस अगेन एंड अगेन. इट गिव्स यू ए पॉइंट. नोट इट. कॉगिटेशन, सिनॉप्सिस, हाउ टू ओपन द आर्ग्यूमेंट में दैट यू हैव टू गिव ए बर्ड्स आई व्यू टू द केस. कि सर आप कोर्ट से बोलेंगे माय लॉर्ड्स बिफोर कमिंग टू द ग्राउंड्स एंड द आर्गुमेंट्स आई विल जस्ट ट्राई टू गिव ए ब्रीफ ओवरव्यू ऑफ माय, दैट कैन बी एन ओपनिंग पॉइंट व्हिच यू हैव टू बी ओरली क्लियर, आपको याद होना चाहिए, रटावा होना चाहिए. Sir, these are the facts, these are the broad issue in this case, that this has happened like a story. जैसे आप स्टोरी बताते हैं एक फिल्म का. Your opening statement in a case ideally should be like telling a story of a film where your sequence should be clear, where your order should be clear, it should be arranged properly. This is how the assessment started, sir. This is how it began. This is the department's contention, and this is assessee's case. Then make out your. दीपक भाई यही बोल रहा चाह रहे थे आप भी.
Yes, sir.
So you have to have a very particular point of thinking कि जब आप किसी केस को अच्छा सा ओपनिंग आर्गुमेंट अगर आपका कई बार खराब हो जाता है ना दीपक भाई, हम देखते हैं वो पूरा केस खराब हो जाता है. तो ओपनिंग आर्गुमेंट का अच्छा होना, ओपनिंग स्टेटमेंट का सही होना भी बहुत ज्यादा जरूरी है. अभ्यास से भी होगा, मतलब एक्सपीरियंस से होगा, और कुछ प्रैक्टिस से भी होगा. जैसे आप कोर्ट में जाकर बैठे, जब आपका केस लगा है उससे एक दिन पहले जाकर उसी कोर्ट में बैठे. मैं आप सबको बोल रहा हूँ, हमारे यहाँ ट्राइब्यूनल में ओपन कोर्ट होता है, आप कोर्ट में जाकर बैठ सकते हैं कि वो जज कैसे हियर कर रहा है केस. निखिल भाई, दैट्स ए वेरी सिंपल वे ऑफ गेटिंग इट कि व्हाट आर द पर्टिकुलर उन जज साहब का क्या वे है कोर्ट को कंडक्ट करने का. तो उसी तरीके से आप अपना प्रिपेयर करके जाइए केस को, तो और भी ज्यादा आपको बेहतरीन रिजल्ट मिल सकता है. आई होप आई एम क्लियर सर. I should say in English that whenever your case goes to the tribunal, you can day before or 2 days before in the court attend that court hearing and see how that judge conducts the court and try to learn from there and make your case preparation according to that. I hope I am clear on this. So your opening statement on a case matters a lot. Your synopsis preparation matters a lot. What I said, your cogitation and thinking on the case facts matters a lot. Your command on the facts of the case matters a lot. Sometimes in the courtroom, oral question comes up, we jumble up, we should not ever do that. We should be very particular when we have to answer queries of the court. Either we should be clear or we should take time. We should not make a, we should not make a guess before the courts. Loose guess. So what I am submitting, Deepak Bhai, is this, that you should try to develop a good synopsis, short synopsis of the case. You should have a proper command on the facts of your case. And then you should have a proper opening statement of the case. And then you should have a proper, see, there are 2 sets of documents which we generally prepare. You can note it down. One factual paper book different and case law compilation different. Many people make it jumble up. Please prepare paper book differently and case law compilation separately. Note it down. Your case law compilation should be separate. And in case law compilation, try to give first Supreme Court decision, then jurisdictional High Court decision, then tribunal decision. Am I with you? So when you have to prepare case law compilation, what are the tips? First, you should go to Supreme Court decision if they are available. Then you should go to jurisdictional High Court decision. Then you should go to other High Court decision, and at the end, tribunal decision of the same local bench or coordinate bench. I should repeat, sir. In case law compilation, first focus to the Supreme Court, then to the jurisdictional High Court, then to the other High Court, then lastly to the tribunal. This is the way. And factual paper book, what you should have, Deepak Bhai? Just as a chartered accountant, I always make it a point, you should always have in your possession in the paper book, ideally, audited ITR, audited final account set and computation. बहुत लोगों के पास ये नहीं होता है सर, और उसको ये भी नहीं पता होता है विद ड्यू रिस्पेक्ट टू काउंसिल की सर ये एसएससी बिजनेस कौन सा करता है, बताइए. आपको सब कुछ पता है दीपक भाई, पर ये नहीं पता कि ये लाला जी करते क्या है, क्या मार्क्स मिलेंगे आपको. ये मैं अपनी बात कर रहा हूं, किसी को प्लीज अदरवाइज ना लीजिए. ये अनुभव से सीखा मैंने कि बिजनेस क्या करता है पता होना चाहिए आपको. हमारे ऑडिटिंग में नहीं कहते हो कि एसएससी का ऑडिट का कौन सा स्टैंडर्ड है दीपक भाई जिसमें लिखा है कि बिजनेस करता है, क्या वो आदमी आपको सबसे पहले पता होना चाहिए. लिखा नहीं लिखा नहीं, मेरे को याद नहीं है, मैं गलत बोल रहा हूँ, तुक्का मार रहा हूँ, है सर?
नहीं सही है सर.
कहीं लिखा है ना कि बिजनेस के बारे में पता होना चाहिए. तो सी दैट हैज इट सेंस सर. When you go to the ITAT or any final fact-finding authority or quasi-judicial authorities like that, who has to do fact-finding also, sir, you have to be clear that what is the nature of business of SSC, what written income it filed, when it was written income was filed, under what section written was filed, what was the amount of written income, sir, When the return came for scrutiny, generally what we do, Deepak bhai, in the high courts, we make a synopsis and list of dates. You know ना, रिट में एक सबसे पहला जो कॉलम होता है निखिल भाई, वो मैंडेटरी होता है, सिनॉप्सिस एंड लिस्ट ऑफ डेट्स. जनरली जो लोग सुप्रीम कोर्ट हाई कोर्ट का देखें, एसएलपी और हाई कोर्ट का रिट, उनको पता है. तो आप लोग एक एफर्ट करिए, जब भी आप कोर्ट जाएं तो रिट्स और लिस्ट ऑफ डेट्स तो आपका बिल्कुल, आपको रटा भी होना चाहिए और प्रिपेयर्ड भी थॉरोली होना चाहिए. और आपका डॉक्यूमेंट पेपर बुक में जो आता है वो इसी सीक्वेंस में आना चाहिए जो लिस्ट ऑफ डेट्स के साथ. पहले आपने रिटर्न भरा, फिर 143(2) का नोटिस आया, शो कॉज, फिर क्वेश्चनर्स आया, क्वेश्चनर का आपने रिप्लाई दिया, फिर शो कॉज आया, फिर शो कॉज का रिप्लाई दिया. ये ऐसे ही तो चलेगा. रिटर्न 143(2), क्वेश्चनर, क्वेश्चनर का रिप्लाई, शो कॉज का रिप्लाई, असेसमेंट ऑर्डर, फर्स्ट अपील का फॉर्म 35, फॉर्म 35, फॉर्म 35 के बाद आपका रिटर्न सबमिशन टू द सीआईटी अपील, and what you say, whatever you file to the CIT appeal in written submissions, then you came to the ITAT, then CIT appeal को जो पेपर बुक दिया आपने, कागज दिया, कोई एडिशनल एविडेंस दिया, कोई एडिशनल ग्राउंड दिया. That is how, Deepak bhai, we arrange the paper book. I should repeat. Case law compilation, I have told you, you keep it separate from main paper book. Main paper book should contain all the relevant, important, significant documents, which may include ITR, audited final account, computation of income, 143(2) scrutiny notice, reasons to believe under 148, etc. Their questionnaires, their replies, their show cause, their replies. And final, are you getting my point? And then in that sequence, you can arrange the paper book, and in paper book should not be clumsy, should be very well pointed. Pleading should be there so that you can make out a case. You can point out the case to the court for interference in your favor. Paper book is a very important document through which you can convince the court to come into your favor, sir. But that requires lot of what you say. आपको फाइल को कई बार पढ़ना पड़ेगा दीपक भाई. मैं तो बहुत बार पढ़ता हूँ. समय कहाँ से मिलेगा, क्लाइंट से फीस कितना मिल रहा है, ये सब क्वेश्चन मेरे लिए जरूरी नहीं है सर, सॉरी. आप कहेंगे गुजर फीस तो बहुत कम मिल रहा है, काम ज्यादा करना पड़ता है, जनरली ग्रीवेज होता है प्रोफेशनल्स का. पर सर थी एथिक्स एंड कॉम्पिटेंस आर डिफरेंट एंड फीस इज डिफरेंट सर. सॉरी, I have learned from my seniors. If you have to do a well done job, then it should be a well done job. Resulting is not in our hands. In court, nobody can say what will be happening, Deepak bhai. As a humble practitioner, I am saying, you have to do a job in a well done job manner. तो इसके लिए पेपर बुक आपका बढ़िया सा बना होना चाहिए. बढ़िया से समझते हैं ना सर? जितना अच्छा आप एक खूबसूरत, जैसे मान लीजिए हमारा विवाह होने जा रहा है, मेरा तो हो चुका है सर, और हमें बहुत अच्छा दिखना है, क्या करें? वो मेकअप वाला क्या करता है? तो ऐसे ही हमारे को आर्टिस्ट की तरह भी रहना है. कई बार मैंने देखा है सर, लिटिगेशन इज ए आर्टिस्ट वर्क. आप समझ गए आर्टिस्ट का मैंने क्यों बोला? पेपर बुक को बनाना, केस लॉ कंपाइलेशन में केसेस को छांट के डालना और सिनॉप्सिस अच्छा बनाना, सर यही आपकी मेहनत है. कमाल. मैं दोबारा बोलूं दीपक भाई, सिनॉप्सिस अच्छा बनाना, पेपर बुक अच्छा बनाना, केस लॉ कंपाइलेशन अच्छा बनाना. एटलीस्ट इससे अगर आपने इसको अच्छा किया तो दीपक भाई मैं मानूंगा कि मेरा आज का सेमिनार सक्सेसफुल हो गया और मैं आपको कुछ समझा पाया. तो सिनॉप्सिस, केस लॉ कंपाइलेशन, पेपर बुक, वी हैव टू वर्क हार्ड ऑन देम. वी हैव टू कीप फाइंडिंग द एरियाज कि जहां हम इन तीनों चीजों को इंप्रूव कर सकते हैं, कि सिनॉप्सिस को बनाने को, केस लॉ कंपाइलेशन को और पेपर. दीपक भाई कुछ ऐड करना चाहते हैं आप यहां पर प्लीज?
नहीं सर.
आप निखिल जी?
That's nothing from my end, sir. Nothing from my end.
ट्रांसफर प्राइसिंग के केसेस में आप लोगों का क्या अनुभव है? आप लोग कैसे पेपर बुक बनाते हैं? चलिए मैं आपसे पूछ रहा हूँ, मैं कम करता हूँ केस. वैसे ही थोड़ा सा इसको और बायलैटरल करने के लिए डिस्कशन को, दीपक भाई कैसे बनाएंगे? ट्रांसफर प्राइसिंग का कोई केस लड़ना है आपको तो कैसे पेपर बुक बनाएंगे?
ट्रांसफर प्राइसिंग का अनुभव कम. आई थिंक निखिल कैन कंट्रीब्यूट मोर ऑन दिस.
Sir, as you rightly mentioned, it will start chronologically how the present submissions were made before the transfer pricing officer in response to show cause notice, the initial submissions, and then the appellate authority.
So you will also include TP study and all those things and from CEB.
Absolutely.
Good.
TP document.
I believe we should go lay emphasis on foundational documents, जहां से जो उसका केस का मेन कॉर्पस है. कई बार दीपक भाई मैंने देखा है चैरिटेबल ट्रस्ट का रजिस्ट्रेशन का आप केस आर्ग्यू कर रहे हैं, आपके पास 12AA के अंदर उसका वो ही नहीं है, क्या बोलते हैं उसको, बायलॉज ही नहीं है, ऑब्जेक्ट क्लॉज ही नहीं है, आपको पता ही नहीं. हम आपको मतलब जो भी काउंसिल है, ऐसा होना चाहिए.
Definitely no.
12AA केस के लिए सबसे पहली चीज क्या है, उसका 12AA का जो उसका जो उसका रजिस्टर, जो उसका बाय लॉज है और ऑब्जेक्ट क्लॉज है, तभी तो चैरिटेबल पर्पस का लड़ाई लड़ पाएंगे यार। लेट अस से आपके पास सर्च केस चल रहा है, आप लिख लीजिए 4 चीजें आपकी फाइल में हमेशा होनी चाहिए। सबसे पहले जब भी आप सर्च केस आर्ग्यू करने जा रहे हैं, 132(4) का स्टेटमेंट, एसएससी का सर्च के टाइम पे क्या स्टेटमेंट था, पंचनामा, सीज मटेरियल, और जो भी सर्च के बाद आपसे सवाल जवाब हुआ है, पोस्ट सर्च इन्वेस्टिगेशन। 4 चीजें हैं दीपक भाई। सर्च केस में आई ऑलवेज से इट शुड बी इन आवर पेपर बुक और केस फाइल। व्हाट शुड बी इन आवर केस फाइल? ए, द स्टेटमेंट रिकॉर्डेड एट द टाइम ऑफ द सर्च, 132 सबसेक्शन 4 स्टेटमेंट, दैट इज सर्वे का स्टेटमेंट हो गया, सर्च का स्टेटमेंट हो गया। फिर उसके बाद जो पंचनामा बना और इंपाउंडेड मटेरियल है, सीज मटेरियल, रेलेवेंट सीज मटेरियल, जिस पे एडिशन हुआ है, जिस पे एडिशन नहीं हुआ उसकी कोई जरूरत नहीं है, और उस पे आपने क्या एक्सप्लेनेशन दिया है आगे जाकर। और पोस्ट सर्च इन्वेस्टिगेशन में कोई सम्मन वगैरह इशू हुआ है तो उसमें कोई रिप्लाई दिया है, तो ऑल दिस शुड कम इन योर पॉइंट। तो सर्च केस में टिपिकल है ये, कई बार निखिल भाई नहीं लगता है लोग, ये बेसिक है। जैसे आपने टीपी की बात करी कर रहे थे, उसमें टीपी स्टडी और फॉर्म 3C भी बहुत इंपॉर्टेंट है मेरे हिसाब से, मेरी कॉमन सेंस में। बिना उसके आप सब कुछ बताते रहिए आगे का क्या किया और केस लॉ बताते रहिए, पर फाउंडेशनल डॉक्यूमेंट नहीं है तो उससे बात बनेगा क्या? जैसे इसीलिए मैंने बोला आईटीआर का, ऑडिटेड अकाउंट का, टैक्स कंप्यूटेशन का दीपक भाई हमेशा सबसे ज्यादा रेलेवेंस है किसी भी केस में। अब लिमिटेड सिक्योरिटी का केस करने जा रहे हैं आर्ग्यू, और आपको आर्ग्यू करना है कि लिमिटेड सिक्योरिटी के बाहर एडिशन हुआ है, तो लिमिटेड सिक्योरिटी का 143(2) का जो मेन नोटिस है उसका कास्ट का रीजन आपके पास होना चाहिए। 12AA का बता दिया, लिमिटेड सिक्योरिटी का बता दिया, सर्च का बता दिया, ट्रांसफर प्राइसिंग का बात कर लिया। और बोलिए आप, जैसे मान लीजिए 148 का केस आर्ग्यू करने जा रहे हैं और आपके पास फाइल में दीपक भाई रीजन टू बिलीव ही नहीं है, और रीजन टू बिलीव जो प्रॉपरली आपको सप्लाई हुए थे वही नहीं पता, उनके वही नहीं है हमारे पेपर बुक में, और आपने जो ऑब्जेक्शन जीके एंड ड्राइव शेफ्ट के हिसाब से दिया था और उसका जो डिस्पोजल है वो भी नहीं है, तो नोट कर लीजिए 3-4 चीजें तो जरूर होनी चाहिए 148 के केस में। सेटिस्फेक्शन, रीजन, आपका ऑब्जेक्शन और उसका डिस्पोजल, वो बहुत जरूरी है। और प्रोफॉर्मा जिसमें अप्रूवल लिया है वो भी होना चाहिए, सैंक्शन लिया है। ये 148 का केस का बता रहा हूं आपको कि रीजन रिकॉर्डेड, ऑब्जेक्शन फाइल्ड, ऑब्जेक्शन डिस्पोजल आप लिखना चाहें, और परफॉर्मा ऑफ अप्रूवल। इसलिए कई बार हम दीपक भाई देखना पड़ता है कि जब भी हम केस आर्ग्यू करने जाएं और कई बार हमें लगता है कि कोई फैक्चुअल डेफिसिट है, डेफिसिट समझते हैं ना आप, डेफिसिट जैसे बजट का डेफिसिट होता है, कोई कागजों का डेफिसिट है, डॉक्यूमेंट डेफिसिट, डीडी, तो उसको क्लियर करने के लिए आपको फाइल इंस्पेक्ट करना पड़ सकता है, सर्टिफाइड कॉपी लेना पड़ सकता है, ये सब करना पड़ सकता है। नोट कर लीजिए कि you may have to apply for inspection of the file and case record in the assessment audit. और डिपार्टमेंट को देखिए, कभी भी मैं तो ये मानता हूं दीपक भाई, जितना भी केस मैंने आर्ग्यू किया यार, उसके अंदर मेरा अनुभव दीपक जी बड़ा जबरदस्त, मेरे पॉइंट सी का भी बात याद आ गया कि मैं तो हमेशा इंसिस्ट करता हूं, जितना भी मेरे पास ब्रीफ प्रैक्टिस है सर, जो भी काउंसिल है वो मेरे से दुखी हो जाते हैं कि गोयल तो बहुत काम कराते हैं, बहुत भगाते हैं, और सॉरी मैं सबको हाथ जोड़ के माफी मांगता हूं। उसमें क्या होता है कि मैं हमेशा बोलता हूं कि जाइए एओ का ऑर्डर शीट लेकर आइए, नोट कर लीजिए मोटा मोटा, जहां पर भी आज कपिल गोयल का मेरा जो भी मैंने आपको बोर किया है, 2 घंटे से बोर कर रहा हूं, लिख लीजिए कि ऑर्डर शीट कपिल गोयल ने बोला है लेना है हर एक केस में। जैसे हनुमान जी का नाम, जय श्री राम, जय श्री राम, जय श्री राम, ऑर्डर शीट लेना है, लेना है, लेना है। और आप कहेंगे गोयल साहब इतना ज्यादा इंपॉर्टेंट क्या है? बहुत, मैंने देखा दीपक भाई ये वो डॉक्यूमेंट है जिससे आधा खेल तो हमारे फेवर में इसी से हो जाता है। मतलब जो ऑर्डर शीट में फैक्ट्स होते हैं और जो असेसमेंट ऑर्डर में चीजें होती है वो जमीन आसमान का अंतर है। पता चले ऑर्डर शीट से तो ये आईना नजर आ गया, प्रोसीडिंग किस मैनर में कंडक्ट हुई है, कितना नेचुरल जस्टिस का वायलेशन है, कितना उन्होंने आपके साथ फेयरली ट्रीट किया है, कितना उन्होंने ट्रांसपेरेंटली ट्रीट किया है, कितना उन्होंने प्रॉपरली लॉ के हिसाब से असेसमेंट करी है। ये आपको सिर्फ एक ही बात से पता चलेगा, ऑर्डर शीट, ऑर्डर शीट, ऑर्डर शीट। आपसे मैं पूछ रहा हूं, सबसे 38 लोग हैं अभी, तो चलिए कोई बात नहीं, मैं ये बोलता हूं कि 148 कैपिटल ए का जो प्रोसीडिंग शीट है वो कितने लोगों ने हमने दीपक भाई लिया? देखिए मैंने 38 लोग इसलिए नहीं बोला कम की वजह से, मैंने वैसे ही बोल दिया, मैं बोलते बोलते बोलता हूं उसको, मेरे को कम लोग ज्यादा लोग से कोई कभी परवाह नहीं हुआ किसी सेमिनार। तो उसमें क्या दीपक भाई कि कितने, आई एम एंजॉयिंग थॉरोली माय प्रोग्राम, दैट इज द मोस्ट थिंग। तो दीपक भाई क्या है कि ऑर्डर शीट के क्या रेलेवेंस है? आपने कितने केस में 148 में ऑर्डर शीट देखा?
मांगते हर केस में सर, कितने केस में डिपार्टमेंट देता है? दैट्स आल्सो क्वेश्चन है सर।
यस, क्या बात कही है आपने सर, आपको साधुवाद, आपके लिए तालियां बजाने का मन करता है मेरा। क्यों? आप वैसे भी बड़े हैंडसम आदमी है, रणबीर कपूर की तरह और हीरो की तरह लगते हैं। हमारी तरह नहीं है अजीब से। तो पॉइंट ये है दीपक भाई कि अगर ऑर्डर शीट डिपार्टमेंट से लेना है तो ऐसा लगता है कि सुरसा के मुंह से बाहर आना है। सॉरी सॉरी, ये कैसा भाव है? आप क्या कर्नाटक हाईकोर्ट का एक डिसीजन है, आई विल शेयर विद यू, आई डोंट नो व्हेन मेनी ऑफ यू नो इट और नॉट। Karnataka High Court has written one of the landmark and most important decision on this subject, sir, कि that order sheet को लेने का जो असेसी का वैल्यूएबल राइट है वो डिपार्टमेंट कभी भी मना नहीं कर सकता है, और उसको ट्रांसपेरेंसी के नाते जितना भी ऑर्डर शीट है वो तो देना ही पड़ेगा। और उस कर्नाटक हाई कोर्ट के डिसीजन का नाम क्या है मैं आपको लिखवा देता हूँ, क्योंकि वो आपका जुडिशियल हाई कोर्ट बनेगा ना।
in practice we've experienced, हम वो सर्कुलर 17 में रिलाई करके कॉपी मांगते हैं, उससे
नहीं, दोनों बातों को मैं आंसर कर रहा हूँ दादा, आप ठीक कह रहे हो, यू आर एब्सोल्युटली राइट। मैं इसका भी एक सेकंड दीजिए मुझे, आप जस्ट गिव मी 1 मिनट।
filing RTIs have been more fruitful to us, उसमें जल्दी आ जाता है।
That is also a very good idea, you are right, no doubt about it, you are absolute, I agree with you that Mr. Goel, instead of wasting our time to get this order sheet like that, but क्या है कई बार वो unnecessarily ना practically speaking दादा वो offend कर देता है उनको, वो पता नहीं खाम में उसको दिल से ले लेते हैं इमोशनली, ये देखो ये हमें RTA में चेस कर रहे हैं, they take it in offensive manner, you say you get it, although you are right, technically also and otherwise also legally कि said that Mr. Goel we can use it, and कई बार नहीं देते तो हमारे पास RTA टूल बचता है, और क्या कर सकते हैं हमारे पास। Anyhow, but I was telling you that courts are very serious about it, sir. That there can be no way that department can say that nahi sahab, we will not give this order sheet. See, Karnataka High Court order जो मैं ढूंढना चाहता मिल गया sir. You can note it down. That is Srimati Manjula. This is by Justice Krishna Dixit, my favorite, one of the favorite judges. Srimati Manjula versus ITO. Order of Karnataka High Court, Dharwad bench. It's a Dharwad bench. Some Karnataka High Court का एक Dharwad bench भी है. 25th March 2019. Karnataka High Court, 25th March 2019 order. Dharwad bench, Srimati Manjula versus Income Tax Officer. Writ petition number. You can note writ petition number also. The writ petition number 106708. 106708/2019. Paragraph number. Paragraph number 9. The request of the petitioner for the furnishing of entire order sheet relating to assessment proceedings in question ought to have been favorably considered by the respondent. Herein, as much as ours is an open governance, moving in the area of transparency, High Court says, petitioner was seeking the copies of public records relating to his own affairs and not of others. No provision of law is quoted to deny such a relief. The counsel for the petitioner is more than justified that the said record is necessary to decide as to whether assessing officer is legally challengeable with a fair degree of success, and therefore withholding such records virtually amounts to scuttling the right of the assessee to seek legal redressal against the assessment order is Karnataka High Court. What more can High Court say? But now coming to the point practically why they don't give, what is the hiatus and what is the impact of withholding it. Now Deepak Bhai, I saw in one of the cases of 148A, what is happening is that in the assessment order, in this 148A order sheet, what was written that AO was in agreement with the assessee that it is not effective. It should be dropped. And CIT Nikhil Bhai was of the opinion, Chief Commissioner, that no, you are wrong, you take it. CIT substituted the opinion of the AO and overstepped it. These facts never came from the order passed under 148 capital 8 clause D. If you have to shine out and find out that this is the way these proceedings have been done and this is the way department is working, then how can you do it without order sheet having been in possession? Am I with you, Deepak Bhai?
Yes, sir. Sir, towards the close of a session, अगर एक request कर सकूं,
please.
In the course of representation, काफी बार कहा जाता है, it is very critical and a very important skill कि आप judges के mood को भापे. You get to know the mood of the judges. Any practical tips and experience that you can share with us?
Yes. Why not? You can have 5-10 points, 10 points rather. You note it down. It's my favorite question. I make it as a challenge for me कि मैं किस दिन ये अच्छा कर पाता हूँ, किस दिन मैं बुरा कर पाता हूँ. ज्यादातर मैं खराब ही करता हूँ, but जज साहब अच्छे होते हैं इसलिए मुझे अच्छा हो जाता है. ऐसा बोलिए और भगवान आप लोगों का आशीर्वाद होता है. अभी ये सीरियस क्वेश्चन आपने जो पूछा, मिस्टर गोयल, हाउ टू गेट द फील कि वेयर जज इज गोइंग. देखिए ये आपको अपनी जो सेंसेस हमें जैसे मैं आप मुझे देख रहे हैं, समझ रहे हैं गोयल साहब कैसे बोल रहे हैं, उनका क्या भाव है कहने का. भाव समझते हैं ना, भाव, भाव मतलब अंडरलाइंग सेंस, इंट्रिंसिक सेंस। तो इंट्रिंसिक सेंस को पकड़ना है अगर आपको, तो कैसे करेंगे, नोट कर लीजिए। कोर्ट का डेमिनर क्या है, कोर्ट किस तरीके से क्वेश्चन कर रहा है, किस तरीके से मूव कर रहा है, किस पॉइंट पे वो ज्यादा एम्फेसिस देखना चाह रहा है और किस पे कम देखना चाह रहा है, ये आपको रेडीली कैप्चर करना है। आपको आर्ग्यूमेंट के दौरान पता लग जाएगा दीपक जी कि कोर्ट, जैसे आपने 3 बातें कही या 2 बातें कही, जो भी बातें कही उनमें से कोर्ट को ज्यादा अच्छी कौन सी लगी और कम अच्छी कौन सी लगी। Am I with you? You have to understand from the way court's demeanor. Many times in faceless, you will not be able to do it most of the time. But in where otherwise you go in ITAT and you have physical hearing, why you can, from the demeanor of the court, you can understand in which direction court is going, or what is the point on which court wants you to more harp upon. As a counsel, आप जैसे क्या होगा कि कोर्ट से क्यूरी आ रही है, आपको उससे पता लग जाएगा, सेंस हो जाएगा कि कोर्ट क्या चाहती है। Should I repeat? If some question comes from the bench to the assessee counsel, then he should immediately understand what direction court is going and what is the drift of the court. You know, drift of the court means bahav of the court. So this comes from various tips are there, from various indicia is there. One is question of the court, demeanor of the court, the paper and the question which they, मतलब उन्होंने आपको कोई evidence particularly बोला, ये बताइए कहाँ है, आपको बोला कि ये केस लॉ बताइए कौन सा है इसके ऊपर, आपको बोला कि इसका सेक्शन बताइए, प्रोविजन बताइए कहाँ है, स्टैट्यूट में क्या लिखा है। तो इससे आपको पता चलेगा दीपक जी कि वेयर दे वांट यू टू, वेयर द कोर्ट वांट्स यू टू टेक देम, और व्हाट इज द डायरेक्शन इन विच कोर्ट इज कमिंग। यू कैन से कि मिस्टर गोयल समटाइम ऐसा होता है कि कोर्ट हमारे खिलाफ चली जाती है, एक कोई प्राइमा फेसी व्यू फ्रेम कर लेता है ओपनिंग आर्गुमेंट से या इमीडिएटली स्टार्टिंग में ही कि वो हमारा खिलाफ करना चाहता है, हम उसको वापस अपनी तरफ कैसे लेकर आए। दिस इज द मोस्ट सीरियस चैलेंज दैट कम्स फ्रॉम दिस कोर्ट क्राफ्ट। आप तो कैसे करेंगे मैं बताता हूं। पहले तो आपने अपनी कूल नहीं खोना, पेशेंस रखना है और ये फेथ रखना है कि कोर्ट इंडिपेंडेंट है और कोर्ट आपका बात अगर आप उनको कन्विंस कर देंगे तो आ जाएगा। अगर आपने हार मान ली फिर गया आप काम से सर, चक दे इंडिया की तरह रहना है। चक दे इंडिया समझ रहे हैं ना, शाहरुख खान साहब की फिल्म जो थी, तो चक दे इंडिया की तरह रहिए। तो वो भाव ना रखेंगे तो फिर जीत जाएंगे मैच, जीत भी जाएंगे इसी सुबह। अब कैसे, यू हैव टू ब्रिंग देम टू दिस पॉइंट कि सर जिस पॉइंट पे आप पूछ रहे हैं उस पे डिपार्टमेंट ने कोई केस नहीं बनाया है, हमारा केस जो मेड आउट डिपार्टमेंट ने हमारे खिलाफ किया वो इस पॉइंट पे किया है, इसलिए माय लॉर्ड शुड सी दिस। और व्हाट माय लॉर्ड्स आर आस्किंग, इवन डिपार्टमेंट डज नॉट हैव एनी केस ऑन दैट। आर यू गेटिंग, नोटिंग इट? सो Deepak bhai, it may be difficult, but it is not impossible. It may be challenging, but it can be done. It is done. Daily we do it. But कैसे करते हैं वो आप पूछ रहे हैं कि Mr. Goel, how to do it, execute it. The point execution can be done like this. You patiently absorb. वो आपकी वेल प्रिपरेशन वहीं टेस्ट हो गई, आपके अंदर कितना मेटल है, आपने कितनी अच्छा से तैयारी करी है, उसी से पता चलेगा। फिर उसमें आप क्या करेंगे, उसमें आपको उसको एक हेल्दी सेंस से लेना है क्वेश्चन को, बेंच के या उस बात को, और उनको अपनी बात को रखने के लिए आपको पहले तो ये बताना है कि जो बायलॉट पूछ रहे हैं उस पे डिपार्टमेंट का अपोजिट साइड का कोई केस नहीं, रिस्पोंडेंट का। आप समझ गए? जो बेंच के माइंड में क्यूरी है पहले उसको आपको एमिल्योरेट करना है, और या उसको आप बोलिए एड्रेस करना है हेल्दीली, कि जिसमें आपको ये मेक आउट करना है कि अदर साइड हैज नो केस ऑन दैट। वो फिर काफी हद तक आपके साथ आ जाएगा। फिर आपको उसको उन्हीं को घुमा फिराकर वहीं लेकर आ रहा है जहां आप चाहते हैं, यही चैलेंज है। वो कैसे होगा वो मैं ये समझाने का कोशिश कर रहा हूं, बड़ा सिंपल तरीके से, बड़ा सिंपल स्टाइल में। एक तो सिंपल रखिए अपनी बात को, ज्यादा कॉम्प्लिकेट करके मत कहिए। जितना ज्यादा आप कॉम्प्लिकेट करके अपनी बात को कहेंगे उतना जज को समझने में दिक्कत होगी, क्योंकि वो हमारी तरह हमारे केस को 10 बार नहीं पढ़ा है, उसको तो पहली बार सुनना है। तो एक प्लीडिंग का सबसे बड़ा नियम है कि जितना आप सिंप्लीफाइड मैनर में बात को रखेंगे उतना ज्यादा बेंच को आप अपने साथ लेकर चल सकते हैं। यही कहा जाता है कि हाउ यू कैन टेक द बेंच विद यू। आर यू गेटिंग माय पॉइंट? तो इसका एक ही मंत्र है भाई साहब की, सब सिंप्लिसिटी इन द प्लीडिंग्स प्रेजेंटेशन, एंड सेकेंडली थॉरो प्रिपरेशन ऑफ द फैक्ट्स ऑफ द केस, एंड 3 यू हैव टू हैव एन आर्ट कि उसको उनको उस स्टेज पे आप उस पॉइंट पे ले जाएं, उस पेज पे ले जाएं जो आपका सबसे स्ट्रांग है और सामने वाले का सबसे वीक है। नोट करिए बात, नोट करिए। कि जो आपका सबसे स्ट्रॉन्ग क्लाइंट है आपको ज्यादा से ज्यादा उसी पे हिट करना है, और जो सबसे वीक सामने वाले का उस पे हिट करना है। अब देखिए क्या रिजल्ट निकलता है।
So there are times when the
I'm
judges
answering your point na. I'm answering na.
yes, perfectly, sir. But there are times when the judges are in not so very good mood and they come down heavily on the counsels.
Take date. Come out. He sir, give me some time, my lords. I will come next time. More preparation. Come out. Very good question. The best way is that कि take date on that day. That's a bad day. May day. May day होता है ना, एयरप्लेन में May day समझते हैं? May day. आप कहेंगे गोल से पता नहीं कहां से कहां चले जाते हैं। May day का मतलब हे प्रभु त्राहिमाम त्राहिमाम त्राहिमाम। मैं हिंदी में भी बोल दिया, इंग्लिश में भी बोल दिया, अदरवाइज भी समझा दिया। टेक डेट, simplicity. My lords, maybe my preparation today is not that good. I will come better prepared on the next. No judge will take offense of it. I'm answering you.
So basically, I have to take it on myself that I am not prepared and give me time.
That's the art you have to show. जैसे कॉमेडी में कॉमेडियन सबसे ज्यादा अपने ऊपर जोक मारता है। क्यों मारता है? क्यों मारता है दादा?
Nobody takes offense of that. सब हंसते हैं, हंसी
उसका हाँ एक आर्ट है वो भाई। आपको भी आर्ट थिएटर है वो भी कई जगह। एक जगह कोर्ट थिएटर की तरह करना है आप, समझ जाइए। नहीं गलती भी है तो 4 बार मान लीजिए आपकी गलती, आपका केस आपके फेवर में आ जाएगा। जितनी ज्यादा पोलाइटनेस, सोबरिटी, सबमिसिवनेस आप रखेंगे उतना ज्यादा फायदा होगा। जितनी ज्यादा विनम्रता। Sir, I have tried my best, Deepak bhai, to cover all the points. Anything which your viewers have any queries? जैसे आपने 2-3 क्वेश्चन पूछे, बहुत अच्छा क्वेश्चन पूछा आपने तीनों। Mr. Goel, how to take the bench with you, how to come out of the bad situation, and how to address to the court in the manner that we can get the desired result. All these I have answered to best of my abilities. But see, Deepak bhai, it comes more when you attend the hearings. मैं तो कहता हूँ कि लोगों को जाना चाहिए, देखना चाहिए, सीखना चाहिए प्रैक्टिकल कोर्ट रूम एक्सपीरियंस को। और वहां तो ओपन कोर्ट हियर जहां पर है वहां तो जरूर जाकर बैठना चाहिए। जब सीनियर लॉयर्स आर्ग्यू कर रहे हैं उनका जो बॉडी लैंग्वेज से आप बहुत कुछ सीखेंगे। आप क्या मिस्टर चैतन्य हैं, मिस्टर शंकर हैं, मिस्टर किंचा हैं, सारे लीगल ईगल्स आपके यहाँ इतने बड़े बड़े हैं। तो आप कोर्ट में जाइए, उनको देखिए वो कैसे आर्ग्यू कर रहे हैं, उनसे सीखिए।
Final query, if I may ask, sir, before we
प्लीज, अरे ब्रदर प्लीज
end the session. कई बार ऐसा भी होता है that we go to the court with a mindset that आज adjournment लेना है, I'm not ready with the case, but court is not in a mood to give any adjournment. So how should that scenario be handled?
See dear, you can just simply say that कि सर मैं adjournment, पहले तो आपको adjourn, फिर then you have to first show your extreme bona fideness in seeking adjournment, that you are not avoiding the court. Court should be made feeling कि साहब आप उनको avoid नहीं कर रहे हैं, आप bench shopping नहीं कर रहे हैं, bench hunting नहीं कर रहे हैं। These are the phrases. तो ये विश्वास जब आप कोर्ट को एक बार दिला देते हैं कि साहब मैं आपको अवॉइड नहीं कर रहा हूं, ये मेरा जेन्युइन ग्राउंड है, इसकी वजह से मैं मांग रहा हूं माय लॉर्ड्स, इसलिए मुझे फोर्टनाइट का टाइम दे दीजिए, उस तरीके से कहेंगे तो वो एडजॉर्नमेंट आपको मिल जाएगी 99.999%। क्योंकि कोर्ट एडजॉर्नमेंट देने में तभी ज्यादा तकलीफ करता है जब उसको ये लगता है कि ये काउंसिल मेरे इस बेंच को अवॉइड कर रहा है। Am I there or not? Straight away.
Yes, sir.
उस भावना को कैसे आप खत्म कर सकते हैं वो मैंने उत्तर दे दिया आपको आंसर। अब रही बात नहीं भी देता है तो उसको आप बोल सकते हैं कि माय लॉर्ड आई एम दो रेडी टू आर्ग्यू बट दिस इज द प्रॉब्लम, आई एम डाउटफुल वेदर आई कुड कम बैक ऑन दिस एंड आई एम सॉरी बट स्टिल माय लॉर्ड से आई कैन आर्ग्यू बट देयर कैन बी ए वे, देयर कैन बी ए पॉइंट व्हिच यू कैन ऑलवेज से कि सर मेरे को अगर एज एन ऑफिसर ऑफ द कोर्ट, आप ऑफिसर ऑफ द कोर्ट हैं जब भी आप कोर्ट में, तो आपको एज एन ऑफिसर ऑफ द कोर्ट कोई बात रखनी है और कोई बात समझानी है तो उसके लिए ये चाहिए होगा आपको रिप्रेजेंटेशन के दौरान। तो आप बोल सकते हैं कि सर ये चीज डॉक्यूमेंट मेरे पास नहीं है और मेरे को आप बोलेंगे तो भी मैं करूंगा बट उसके बीच में आप मुझे मांगेंगे ये वाला पॉइंट तो मेरे पास नहीं है। देन यू लीव इट टू द डिस्क्रिप्शन ऑफ द कोर्ट हाउ टू गो अहेड, वो डेट मिल जाएगा। You can just point out that I am not in the position to what you say again कि मैं अपना एज ए रिप्रेजेंटेटिव ड्यूटी जो मुझे करना है ऑफिसर ऑफ कोर्ट के नाते वो शायद मैं ना कर पाऊं इन दिस सर्कमस्टांस।
पॉइंट टेकन सर।
ये पॉइंट बिल्कुल आप जो पूछ रहे हैं सारे प्रैक्टिकल पॉइंट्स हैं और रोज कोर्ट्स में हम ये देखते हैं कि जब हम कोई बार डेट लेने जाते हैं, कोर्ट कहती है हम आज इस मैटर को सुनेंगे, तो आपको ये बात बतानी होती है कि कोर्ट को सर ये मैटर अगर आपने आज सुना तो इससे जस्टिस शायद ना हो पाए सर, तो थोड़ा सा आप इसको डेफर कर दें ताकि आप जस्टिस करें.
Point well taken, sir. Nikhil sir, any questions, any open questions from the participants or anything that you would want to add here, sir?
One related question, sir, on that point. One of the points which I came across is that at least at the tribunal level, the new ARs, they are generally not heard of. It takes the judges give them very, very less time, or they just say, okay, is it a covered matter? Only then you can argue. How to tackle this at least during initial stages of practice? Sir?
See, bhai, Nikhil bhai, ये तो क्या है, with due respect, I'm sorry. See, when I started my career 15 years back, I see in hindsight, and I do not know, maybe my legs were shivering. And then also court heard me and gave me one of the ample times, which even today I sometimes don't get. So I really feel bad when I hear these points from your side, that Mr. Goel, and this is reality sometimes, that with due respect to the bench, that if the youngster is not heard, see, always it is said that youngster should be given more chance to speak and should be given more leverage. Even if he speaks something wrong, it should not be taken adversely. That kind of liberality should be there always. That is the unwritten law. But Nikhilji, if it is happening, it's not only a sad state of affairs. It is somewhere you say young bar is a very important bar in in this profession at least. So if this attitude of the bench, with due respect, it should be taken first by the bar concerned. It's a bar and bench relationship point.
Noted.
I'm not a very old man or a very, very senior man, but I'm saying you with my experience. Then it comes, then it is the first duty of the bar of that place to highlight it to the concerned vice president or the head of that particular zone. That, sir, youngsters are not heard of. And this is the problem. Second way, that is another level, you will say कि गोयल साहब हम तो नहीं कर सकते, वो तो हमारा बार का प्रेसिडेंट को ही सोचना है. अभी आप क्या कर सकते हैं? आप यही कर सकते हैं कि सर, आई एम ए यंगस्टर, I'm not having that kind of what you say, humbly you can always say, that kind of, sir, experience at my back. So maybe I may commit some mistakes. So my lord have to bear me out for the cause of justice. Relate everything to cause of justice. That if I am not given the audience which I as a youngster, sir, deserve, it will be very, very, it will have a very damaging impact on the justice.
Understood. Thank you. Thank you.
But justice, my lords, will be done. आप उनको भी कुछ मत कहिए, indirectly बोलिए, उनको मत कहना कुछ भी आप. You know, sir, my lords, but justice will be done in a scenario if a voice of our youngsters is not properly given harkan and ear. Are you getting my point?
Yes.
So you have to elevate in a manner. आपको उसके लिए शब्द ढूंढना है, थोड़ा बात कहने का तरीका आपको अच्छा करना है, अपना बात बोलना भी है कि सर ये आप देखिए अभी तो मैं नहीं बोल पाऊंगा एज ए यंगस्टर, तो आप न्याय कैसे होगा, जस्टिस कैसे होगा, हाउ विल यू फाइंड द ट्रूथ एंड जस्टिस? दिस इज अ फाइट टू फाइंड आउट जस्टिस एंड ट्रूथ एंड जस्टिस. व्हाट वी आर डूइंग हियर? अदरवाइज व्हाट कोर्ट इज डूइंग? कोर्ट इज टू फाइंड आउट जस्टिस एंड ट्रूथ ना. कोर्ट कोई और थोड़ा, कोई एंटरटेनमेंट थोड़ा चल रहा है. सॉरी, आपने ये नहीं बोलना, पर उनको ये बात रियलाइज करवानी है कि दैट इफ दे डोंट हियर यू प्रॉपर्ली देन देयर विल बी नो जस्टिस. फिर उनकी कंसेंस को प्रिक करना है कि दे आर डूइंग रॉन्ग इन हम्बल मैनर.
Okay. Thank you. Thank you. That is I hope that is a very tip that is taken seriously by participants going forward.
इससे क्या होगा निखिल जी, देखिए दो चीजें हैं. एटलीस्ट आपका जो भावनात्मक पॉजिटिव सेंस है एज ए काउंसिल, कि आप उनके खिलाफ नहीं, आप अपना बात को रखने के लिए, अपना क्लाइंट के लिए जेन्युइनली अपना बात रखना चाहते हैं, तो वो बात आपको उनको बताना ही है, चाहे आपको हिंदी में भी बोलना पड़े, कोई प्रॉब्लम नहीं है. नो प्रॉब्लम्स, नो हार्ड. हमारा प्रधानमंत्री हिंदी में बोलता है, बताइए अभी हमारे को हिंदी में बोलेंगे तो क्या हमारे को कोई जेल भेज देगा क्या? मैं तो ऐसा बोलता हूँ, सॉरी है. जिस लैंग्वेज में आपको बोलने में कंफर्ट रहता है बोल दीजिए प्लीज, पर बोलिए शालीनता से, बोलिए विनम्रता से, बोलिए हम्बल. कोई गलत वर्ड्स का सिलेक्शन ठीक है.
Thank you, sir. Thank you. Chairman, sir, please.
Sir, with your permission, can we consider the session as concluded, sir?
Yes, sir. Deepak bhai.
We are highly grateful to you, sir, for the Power Pack deliberations that we've had. The aspect of invoking constitutional matters in a tax matter is a new learning for all of us. We all hope to learn more of these and try to implement this in our tax cases. And we also eagerly await the outcome of your writ petition in Punjab High Court against the constitutional validity of 150
टाइम लगेगा दीपक भाई, ये लिटिगेशन का चार्म है, अभी नहीं
लाखों से सी का भला हो जाएगा सर।
नहीं हम लड़ रहे हैं और भी। आई एम वेटिंग कि अगर आप मुझे कोई आई एम वेटिंग कि मैं और हाई कोर्ट में भी यही पेटिशन जो मैंने फाइल किया मैं कर्नाटका में और हाई कोर्ट में भी फाइल करूं। आई एम वेटिंग फॉर दैट प्लेटफॉर्म टू बी गिवन टू मी दैट वेयर आई कैन यूज माय होमवर्क टू अदर हाई कोर्ट्स आल्सो।
We also wish your birthday your son a very happy birthday. May Lord give him success and health and prosperity. I now request CA Nikhilesh to propose a formal vote of thanks.
Thank you, sir. Thank you, sir. And just to reiterate our chairman's words, thank you, Kapil, sir. Always a pleasure to attend your session. Thank you for your time. Invoking constitutional aspects in a tax matter, immense knowledge, immense experience. It shows the range of thinking that can be invoked going forward. And on behalf of KSCAAA team, special wishes to your son on the birthday. And thanks to our chairman, Mr. Deepak Chopra, for organizing this session. Thank you for your efforts, sir. None of it would be possible without your efforts. Thanks to KSCAA team as well. And last but not the least, thank you to all our participants for joining in on this weekend, Christmas Eve, and making it a very, very fruitful, amazing session. And we sincerely urge all participants to try to implement today's learnings, which has been very, very immense. And please implement it in the upcoming days, not only as part of this program, but also as part of your professional practice as well. Thank you.
Thank you, sir. And on the participant count, sir, we had 99% attendance today. Hamara group, a steady group is of only 41 participants, and we've had.
No, sir, Deepak bhai, see, please, sorry. I really enjoy my, you know how I speak. It does not matter me, at least nowadays, तो अभी तो बहुत ज़्यादा इतना बोलने के बाद मेरे को अपना पढ़ाई का खुद ही रहता है। मेरे को कोई with due respect ज़्यादा भी हो और कम भी हो, ये मेरे लिए न्यूट्रल फैक्ट है। न्यूट्रलिटी समझते हैं ना, रेवेन्यू न्यूट्रल थ्योरी, ये न्यूट्रल है। मेरे को जो बोलना है वो मैं बोलूंगा, चाहे आप जो मर्जी कहें या ना कहें। और यही मेरा सबसे बड़ा वीकनेस और कमजोरी भी है। नवीन खेरीवाल जी हाथ उठा रहे हैं, क्या कह रहे हैं, बोलिए साहब को।
Sir is there.
Hello, I am audible, sir.
राम
Yes,
राम नवीन भाई।
Sir, I joined later, but I thoroughly enjoyed the deliberations. And this 41, what I am advising our chairman and Deepak and Nikhil sir also, this 41 will now turn into 1,400 when we invite you for next year KSCA conference.
यही नवीन भाई आप लोगों का प्यार है, इसी वजह से मुझे भी अच्छा लगता है। I really love and enjoy, you know, the quantity, and you yourself a very learned man and thorough gentleman. See, आप लोग तो मेरे से ज्यादा विद्वान हैं सर। मेरे को ये लगता है कि अच्छे आदमी के साथ रहकर थोड़ा आदमी को हमें भी सीखने को मिलता रहता है।
Thank you, sir. Thank you very much.
Thank you. Thank you, Naveen sir. Thank you, Deepak sir. Thank you, Kapil sir. And happy Christmas and Happy New Year in advance, sir. Take care.
Thank you, sir. May God bless all of us and we remain healthy and wise, sir. Progressive. Thank you. God bless you. Shri Ram.
Yes, sir.